Di- Division bench item 1, 2, and 3.
Person to Lordship's last order. My instructions I have already handed over to the other side,
Instruction.
and I have sent in an email, Malad. And my officers are just waiting out at the security check, Malad. They are not allowing them. Just I have the court master has also granted permission, but they are not allowed. Yeah, yes. Then can you just 1 minute only? I'll hand over the hard copy.
Before your lordships, till those officers arrive. Well, in this case, today, one of the affidavit has been filed by the District Legal Service Authority. Earlier, highlighting the pathetic condition in the camp there at Daboka. Earlier, the affidavit of the District Legal Service Authorities was not in conformity with the observation that I had gone and seen myself. Now, this affidavit that has been filed a few days back, this is what is the actual scenario at the camp, my lord. Your lordship will find that affidavit was filed on 3rd of June 2024.
Not DLSA, ASLSA.
Assam State Legal Service Authority. This is the ground reality at the camp. Sorry. They have highlighted around 8 points in that affidavit.
But this is relating to item number 3. Item number 3. My instructions are relating to item number 1 and 2. 1 and 2. Yes, sir.
I am only an amicus curiae.
Item 3, I think we'll have to fix some other day because of the fact that in the first phase, we are taking up only few items so as to ensure that this judgment of the Supreme Court is implemented. So there are deficiencies, no doubt about it, but it will take some time for us to reach there and then take appropriate orders. So we'll take up item 1 and 2 and then come to number 3.
But number 3, if your lordship is fixing it up on some other day, then I may be excused for today. I'll some other matters fixed. No, I'm not seeking an adjournment, but because your lordship has to look into the affidavit of item number 3 and
We'll take up first item 1 and 2 and then
yes,
time permits.
item number 3, so far the affidavit is concerned, they have highlighted the problems there and they have suggested some recommendations. Those recommendations are fair enough, Malad. I think those can be implemented, Malad. But my junior will be here. I have some matter checks around. Deeply blessed.
Well, Lordship, may kindly take up order dated 28/3/2024, last order. Paragraph 3, Malad. Lordship has referred to the order dated 10/10/2023, Malad. Referring, para 3. Referring to the directions contained in para 2 of the order dated 10/10/23, it is submitted on last occasion. Only 8 CCIs were inspected, but on 27/3/2024, the High Court Committee had made 58 visits covering the CCIs of Kamrup Metro, Kamrup, Dorong, Baksla, Sonitpur, Nagaon, Morigao, Kachar, Hailakandi, Karimganj, Nalbari, Borpeta, and Udalguri districts. And inspections were carried out, keeping in view the form number 46 of the Juvenile Justice Care and Protection of Children Model Rules 2016. It is submitted that the reports are under compilation and will be presented before the Honorable Court on the next day. But this inspection, my lord has directed to complete the inspection. It is completed, my lord. The report is placed before your lordship, my lord. In that branch, my lord, we have indicated. Then second, my lord, the compilation, in compliance with directions contained in para 4 of the said order dated 10/10/23, the High Court appointed committee has already been formed pursuant to directions contained in para 5 of the said order. It is submitted that the State Child Protection Society had conducted a one-day training program of social workers. But this we have already replied on last occasion. But kindly come to
Just a moment.
lordship.
In this Juvenile Justice Board training program, I don't know how effective it has been because there is still delay in the conduct of the proceedings before the Juvenile Justice Boards. They should be given more training so that because of the timeline given in the Act within which the proceedings before the JJBs should be completed.
Lordship.
As per the latest reports received, the sittings are not taken up regularly.
That my lord will take note of. My lord, my officer is there.
Because there should be some mechanism. Madam, there should be some mechanism by which you all take a constant monitoring of the sittings of the Juvenile Justice Boards, because the data which we have received in the last meeting which was placed before us, the delay in the taking up the matters, which goes beyond the period of 4 months. This is still happening in the state. And the conditions of the JJBs, they don't have their own office. In many places, they don't have their offices. They don't have facilities for even water and other amenities. Also for the children in conflict with law, all with the otherwise the children who are brought there.
My lord, with your permission, like to submit that we have held the training programs, and apart from our holding the programs for the social workers, my lord, the NIPSID and all the other such organization associated with the government have been giving proper trainings to the Juvenile Justice Board social workers. Apart from that, my lord, we have tried to provide child-friendly atmosphere at the Juvenile Justice Board, and the report that we had received 2 years back about the infrastructure also, we have tried to improve as much as possible. My lord, my lord, this is, as our High Court notified committee have visited, we have also, my lord, we have also, the High Court notified committee have also observed while visiting the observation homes that there are some petty offense cases related to children who are yet there. So we have also given in the recommendation that such cases needs to be addressed at the earliest. Apart from that 4 months period, the such cases may be, if the bail is given earlier. So this is also an observation, but as my lord, the principal magistrate says it, so we are focusing on the social workers more. And we have tried our level best for proper infrastructure facilities, and we'll be collecting more reports as per the observation of Honorable Court on the infrastructure facilities. But mostly the courts have been provided with child-friendly atmospheres.
Once we complete with all these paragraphs, we'll again come back to that, this point of training. Because we feel that apart from the training of social workers, there has to be a training of the principal magistrates as well as the members of the Juvenile Justice Board, because otherwise what happens is that they are the people at the field who will have to implement the timeline.
Correct.
So training of social workers, that is very good step. We appreciate that, but the fact is that we want something more so that the principal magistrates as well as the other members, they also take up the sittings in the right earnest.
Well, that if lordship takes up, that will be good for us, because from our side, my lord, since the principal magistrate is heading that thing, my lord, there is some limitation on our part.
So we'll try to address that.
Yes,
My lord, as I just said that for children who have been apprehended because of petty offences may be released at the earliest, so that the burden on the observation homes also is lessened.
listen.
So that is just a.
Once we complete this part, we'll come back to that training program again.
Yes. Yes. But coming to para 5, my lord, of the last order.
There are 5 draft rules.
Para 5, the draft rules, my lord. My lord, as regard the draft rule, my lord, we have in our reply, we have said the rule is already drafted, my lord. It is with us, my lord. Just it is by tomorrow, no? By tomorrow, my lord, it will be placed before the government. My lord. Yes, sir.
As mentioned earlier, on 20th of March, we had the stakeholders meeting at the state level. So representative from the petitioner side was also there. They had come from Delhi, and we had tried to incorporate all the comment, suggestions, recommendations they have given. But my lord, the cross references, checking the cross references, minute details while drafting the draft took some time. So we just took 2 months to complete that. We have compiled it, and we have not placed it as an annexer, my lord, but we have submitted it through
Yes.
mail, and we have brought the hard copy also, if my lord would.
For lordship's perusal, we have a copy.
No, no, we'll not peruse. Let it be notified by the competent authority,
Lodge.
then, because we cannot suggest what should be, because already there is a drafting committee. They have, after consultation, made a rule that will be now placed. This is not
Yes.
at the final stage. There
Yes.
may be some modifications at the part of the government.
Got it.
So thereafter, we'll look into it.
Lodging.
Because as a bench, we can't just give our advice on the legislation, proposed legislation.
Lodging.
So
We have given the copy already to the other side, my lord. Draft copy we have already given.
We have received, madam, today morning we have
Yes,
received the copy.
We'll be placing it before the government, my lord.
let that be taken up in the administrative side, because for us to comment on a judicial side,
So as a senior government advocate, Mr. Nath, what is your expectation to be this process to be completed and to see the light of the day by this?
But I have talked, my lord, that at the stage of, at our stage, Malad, it is ready, Malad, by tomorrow it will be placed with
No,
the
no,
government.
after
Malad-
presentation, you are representing the state also.
Malad,
But how much time can we expect?
I-
Because already we are delayed.
correct, Malad. I have suggested, Malad, that within a month period, they should do it, Malad. Because at the government level,
That initiative should be taken.
government level, some
whatever
scrutiny
way,
will be
because,
there. It will-
in the meantime, many months have gone. Ultimately, that has been submitted. Anyway, we are not blaming anybody.
Malad.
It takes time because ultimately you need a good rule.
Lot.
But since everything is done, now it's all is in the court of the government. We'll expect that it
Correct.
should be at the earliest.
Malad, definitely from our side, Malad, will
Mhm.
insist, Malad.
But we appreciate that you have done the work and then at least the rules have been framed. Drafting at least it
Drafting
is
has been-
over.
Drafting.
That
has
is
been
a
done.
huge
Taking
task.
all the suggestions and recommendations, it is drafted, Malad. It is done.
We appreciate that.
Lot.
But although there is a delay, but we appreciate that
Correct.
ultimately it has been drafted.
Yes, sir. That's it.
See,
Uh,
in fact, at paragraph 6,
6.
if
The-
you can see, we have
Lots.
already expressed our view
Yes, Malad.
that we expected that by today's date, we could have with the notified rule. Anyway, this is not an
Notification,
adversarial litigation,
notification we could not. It
but
should
this
some-
was an expectation of this. court.
Correct,
So we'll
correct.
extend our expectation.
No, Malad. We pray for that, Malad. In between, the election process was also
Oh,
there.
understood.
Not it.
We told you, we are not blaming anyone.
Malad,
Although there is a delay, but we still appreciate that it has
Logic.
been done ultimately.
and as regard the child protection policy, Malad,
Mm.
this policy has already been submitted, Malad. We have, in our paragraph, Malad, we have stated, if Lordship is holding the bunch, Malad, that bunch, Malad, I have given,
Mm.
kindly, Malad, kindly come to the next page, Malad, second page of that bunch. The first para, Malad, as regard para 8, Malad,
Which
The-
this you are saying about this month?
the bunch I have given, I have paginated, Malad.
24th June.
I have paginated 24th June. 24th June, I have not marked any page number. Malad, after 2 pages, Malad,
It
Lordship
will
will
start
find.
from page 1.
Page 1, kindly come to page 2. Nice. Amadya city दिया ना मैं कुछ Amadya city presentation पढ़ना है report of the commission.
Yes.
Well, in page 2, we have stated as regard the policy, as regard para 8 of the order, we are referring to the 1010 order, my lord. The state child protection society, Assam has submitted the draft child protection society policy to the government for approval and notification. Some changes are being done at the government level, and it is also at the final stage, my lord. It is also, government is doing some changes, my lord. It will be done, my lord. But Lordship has expressed that it will, by the next date, it should have been notified. That we could not do because of the same reason. Kindly allow us some time. Within, my lord, we expect that
But
within.
by the next date, certainly.
Yes, yes. I'll definitely, my lord. I'll convey, my lord. I'll convey that. Lordship. So, my lord, these are the query, my lord. In fact, Lordship has in paragraph 9 again, my lord, reiterated that we once again reiterate our hope and trust that before the next date of listing, state government would do the needful notifying the child protection policy. High Court appointed committee shall be able to complete the inspection. That inspection we have done, my lord. Annexure A1, we have annexed here. In the bunch, my lord, Lordship may come to page 5. This is the status of all the inspections done, my lord. Altogether here, Lordship will find 93 CCIs are there. And we have also taken some action against some of the CCIs, my lord.
How do we know the status of that homes which are visited? But this does not give
Pardon, my lord.
conditions of that.
But,
homes.
reports are there. Reports we have annexed. From page number 20 onwards. Annexure G 19 onwards.
Mr. Das,
Yes.
will from both of you will Await your inputs and response.
Yes, Milord, actually problem is that, Milord, I received the affidavit.
No,
and
no, we are
documents
not-
today morning itself.
Not today.
Yes, but
We're not now.
will definitely come up.
On the next day. We
Fine.
cannot give you right now to response to this.
Annexure G, my lord, we have annexed page 19 onwards. Well, detail of the recommendations and the report lordship at annexure G, page 19. Lordship will find at annexure F, page 17, overall assessment of visit we have stated. my lord.
Where is that?
Page 17.
17?
17.
No, but once you asked us to see those, you have mentioned that there are reports.
Lordship.
I've casually gone through one of the reports at page 19.
Yes, my lord.
Now here, third last comment
My lord.
is that there is one girl above 18 and she is mentally sick.
Lordship.
Now, under the Mental Health Care Act, again, there is a duty to of this home to see that the a girl who is has those issues has to be treated in a manner prescribed under the Act. Therefore, there must be a caregiver. There must be she must be assessed
Lordship.
by an institution which is having the facilities of mental health care. Therefore, either LGPI Tejpur or any other institute which the government feels is competent to assess the mental condition of a girl who is now adult. 18 years, she'll be an adult. But if she's if her mind is not developed, she can still be juvenile for certain purposes.
But some step have been taken.
After this visit, we have taken steps of transferring her. And actually this, my lord, this girl was a victim. So the whereabouts of her was not found initially. So she was kept in that order. We had also visited earlier before this committee was notified. And we were thinking about how to take about this step. And after the High Court and Honorable Court notified committee visited, we have shifted the girl to a proper center where her condition is being taken.
Because there has been judicial interpretation where it says that if the adulthood of this girl child was was mentally challenged, consummate to the mental capacity, she can still be treated as a juvenile for the purposes of certain offenses and all. She's still to be a juvenile. So therefore, if you treat her as adult right now, that means you'll have to take her out of the system. But where will you rehabilitate?
Placed her. We initially took her to Ashani, which is especially an institution for taking care of special needs. And after that, we have shifted her to Jalukbari. So we have taken steps for her, and we have been taking follow-up from the respective institutions, whoever are looking at her. She's not as mental, like proper mental, but because of those things that happen in her life.
Trauma.
So,
Mental trauma.
Trauma induced.
yes,
Okay.
issues are there. My lord, if you permit, we like this, we have taken similar steps of de-recognizing two institutions. also after the visit, who have not been found totally failed to have followed the norms as per the JJ. We have also revisited two CCIs after the recommendations to properly monitor again. So revisit was also done in between this. And we have also asked for explanation first, and they have submitted the reports, and proper implementation of the recommendations is being under observation. Madam.
Okay, and there is one,
Because this is a continuous process. It's not that it will by the High Court Monitoring Committee. It's a responsibility cast upon the department also
True.
to monitor.
Those cancellations and all, we have annexed below, annexure B, page 9, lodgeable fine. They were cancelled. There are two below.
So I think the subject.
There should be some surprise visit also. Apart from regular routine visit, there should be some surprise visit also to the CCI.
no, Mr. Das,
My lord.
if we create too much of what you call duty right now, because now
No, what I'm saying is that since it's a continuous process, my
no,
lord,
we understand, but
That's right.
we have, we
Lots of
we
work
are
around,
we are
yes.
just thinking aloud. You see, once everything is being put into
Set in
place,
place.
now till now everything nothing was there. Now
Lordship is
everything is being put in
Yes,
place. So once the groundwork is done, then we can always say that the officers will also have spare time to do a surprise visit, to have a revisit in the places, to see the infrastructures once again. But at this stage, when everything is in a formative stage, you put too much of duty to the officers,
Yes, yes,
then things, their tendency to collapse.
yes, that's
Uh,
right.
Once we have a baseline, then we, because
Let
this
us have
bench
the
is,
foundation first.
because this bench is also a continuous bench. So we will definitely take care of it. You have,
Yes.
you rightly
Now,
said, we'll
what
take care of
prevents
it.
is the social audit, I think. so.
Well, that remain, that
So-
social audit kindly, page
Subject
two, my lord.
what my brother says,
Lodge.
more or less, you have some answers to each of the points.
Lordship,
Earlier, we have directed.
lordship,
Draft rule is finalized.
Yes.
It is in the state.
yeah,
File policy is finalized.
or it is placed before the government.
It is placed before the government.
Yes,
So in that regards, we can wait.
lordship,
Now, next is so far relating to the social audit.
lordship,
And you have taken a decision that Guwahati University some
we have given,
institutions.
we have
Now,
given,
this is also on 24th Monday.
yes, yes.
Is that it? So
No,
before the case is listed today.
No, it is, my lord, on 11, no, kindly come to page 2, second last para, my lord. Second last para. Of that bunch, my lord, page 2, second last para.
Yes.
Well, as regard para 14 and 15, in response to the Honorable High Court order dated 28/3/24, a meeting was held on 2/5/2024 with the head of the Department of Law, Guwahati University, for conducting social audit of childcare institutions. As per discussions held during the meeting, interest was shown by the Department of Law to conduct the social audit in all the CCIs in Assam. Accordingly, the Department of Law has submitted the proposal along with budget via letter number 11/6/2024. That is at page annexure I, page 109.
Okay. Now that is what we will require on
Yes, yes.
next date.
Yes, yes,
And
They-
other parties,
they haven't given.
Find out approval result and
Okay.
I'm not able to give.
Okay. And it is, I'm told that it is already approved by the government.
Oh, very good.
okay.
Lordship.
Very good.
Financial implications have a financial advisor or you are the seller.
No, no, it is approved.
Achha, insofar as the inspections have been done, we see that the home is equipped for male and female both. Correct? The homes which were visited, they are for both male and female child.
All my lord. Some are meant only for girls.
Okay,
Some
how many are there for girls?
My lord, as far as government homes are concerned, we have observation home at Jalukbari for girls, observation home at Boko for boys, similar way in Kachar for boys. And in Jorhat, we have
Means in respect of those homes where there are also female, we wanted to know about the
Sanitary.
welfare and the hygiene care of the girl childs.
Right. We have, we took steps. We have the Swachhta action plan also, my lord, under which we do proper Swachhta methods, teaching methods at the CCIs. Yearly it is done, and apart from that, for menstrual hygiene and all that, they are paid, and we have provide with sanitary
Okay.
towels for the girls.
Okay. Mr. Chaudhary, so far as you were concerned,
Yes, Rashid, in fact, the instructions which I received, the review of the Rashid was how the center was monitoring the amount that is being spent. Rashid, the general statement has been sent to me. That will not suffice. Because they,
See, Mr. Chaudhary, if their response is like that, we may require their personal presence to explain. They should take it seriously. This is this bench is taking up the mandate of Supreme Court as well as implementation of this. Let us not take them so casually.
in fact,
Give the message.
I have communicated the views earlier expressed by your worship. Because a general statement will not do. They said that we are keeping in touch, that keeping in. touch
Or do we presume that they don't want to monitor how the finance is being released and
No.
how it is utilized? We'll think it that way.
That cannot be,
Then
that cannot.
means you'll have to impress upon them to do it in an appropriate manner, because
If I would just pray before your lordship, if it does not, if they do not come up with the case, lordship will definitely direct some officer to be present.
yes, it's
because you see, this is the only way. You see, number one, we the inspections which are being carried out is by a court monitored committee, and therefore we have full faith on the committee as they are functioning under our orders. Now, therefore, number one, we are not doubting what the committee is doing, but there is another way to have the check and balances. Because if the Union of India, who is the major sponsorer, if they find that there are the money which they are parting is not utilized as per their idea, their program, then definitely you will flag it. We insist on your affidavits because of the fact that this is the only way we can find out from the union government as to whether they are satisfied that their money provided is well spent.
In fact, lordship, from what information has been supplied to me, I find in a year what amount has been sanctioned by the central government, more money has been spent. How? That was a question that I had put there. They have to explain that. It cannot be like that.
No, money spent can be high because of the fact that you see there are certain programs which are undertaken by the state, like for example training.
So that will be over and above the money which has been given by the central government.
Hmm.
But if the central government gives me a figure that 1,000 rupees has been sanctioned, and they give me another figure 2,000 rupees has been spent, then
yes.
Correct.
that, in fact, that is one issue I have taken up.
Okay.
And you express the anxiety of this court
I
to them
I'm not sure.
and concern.
I'm not sure.
And we know how to get reports and information. Let them also understand. We know.
I
Yes.
এতিয়া inspection ৰ report কথা আমি আৰু কি দিব? আমি ইয়াত 14 টকা বাকী আছে। 14 টকা এটা 70 আমি next day তো দিই। আমি রেকমেন্ডেশন মধ্যে কি কি কাম করবো হয়তো বইটা আমি খুঁজে পাই এখানে মাথা কি কাজ করবো রিপোর্ট করে আমি কম্পাইল করে এখানে দিয়ে কম্পাইল করে সেখানে
Yes, Mr. Das,
Yes, madam.
and who is representing Boston? Yes, anything you want to add or you want to respond on the next?
But just
My lord, the same response as Mr. Das, we have also received it today. The draft rules have also been received. It runs 150 pages or not. My lord will allow us some time to go through the same and respond. Otherwise, my lord has already indicated on all the points, even regarding the infrastructure, how the finances have been utilized is supposed to be.
So according to you, what kind of order we can pass today?
Today, my lord, your lordship's last order,
Hmm.
to what extent they have, my lord, implemented?
Yes, we'll
and-
record that and
yes,
we will
and-
await for the draft rules and file policy to be
Yes.
notified by the next date.
another
And in the meantime, we'll want a response from both
Fine, my
of
lord.
you as
Yes.
regards the report they have submitted by
Yes.
the High Court Monitored Committee.
Yes.
And we will also want a response from you as regards the infrastructural issues.
Yes, my lord.
That response we will want, and we'll also, you can have
Basically,
a.
I am from beginning, I am interested in the infrastructure
Ah,
issue only.
So no, we'll have to, don't be interested only on one.
No, no, no. Because this,
See, so therefore you can have a talk with Register Judicial.
Yes,
and
madam.
you can also have your own report from the
Yes.
registry.
yes,
My
So
lord, I'm sorry, my lord, actually regarding the infrastructure issue earlier, primarily the issue was being taken up, reports were also filed. But after constitution of this honorable bench, it was deemed fit to see how the finances have been utilized and how much ratio has been given by the state and the unit. As such, till receipt of that, this issue was referred. That may also be kindly taken up by.
your lordship has done the correcting, my lord, because the foundation has to be there. So
no,
lordship has
see,
taken
two
up the
things,
rules.
you
and-
cannot, there are many issues. You cannot jump
my lord.
everything. One by one, we'll have to,
True,
something
my lord,
will have
that
to
is-
wait. Otherwise, it will be jumbled up.
Yes, sir.
So more or less, the first 3-4 issues regarding policy, draft rules, it is in the way of solution.
Yes.
So let us wait for that, and now let us go to the next stage of
level.
Because you see,
infrastructure.
the presentation which was made by Mr. Sharma,
My lord.
that really clicked because of the fact that there was clarity in what are the first initial requirements.
True, my lord.
So we are going on that basis as a, we have taken that as a base and then we are going ahead. Now, if two things fall into place, that is the rules as well as the
Policy.
policy, if they come into place, then that will take care of all the other issues, including infrastructure.
True, my lord.
Correct. Now, we are more interested to know about the utilization of money, because that is the best way to assure to ourselves that the money which is coming is spent at the for the right purpose. Because we don't want that the money is coming for the child welfare schemes and the first thing people are doing is to purchase a car. Correct. So first is the infrastructure issues which are, you see, here again we have a difficulty. Number one, we are taking up the matter in the as a in the committee also. and we are also taking on the judicial side. Therefore, we must always be conscious about that we are not over reaching our the powers. The infrastructure is one which we are taking up on the administrative side also. So if we try to jumble both things up, then what happens is that we cross that thin line. From administrative side, we are jumping into the judicial side. So therefore, we have to take this infrastructure on the basis of reports which are available. So therefore, that's why my brother had told you that we need your inputs now. Insofar as these institutions are concerned, so that we are proceeding on in a premise that we are not doubting the committee at all, because it's a court monitored committee. So therefore, we are not doubting its activities or the inspections taken. We treat it as a sacrosanct duty they are doing. So therefore, we have no other way but the government of India to tell us if anything is lacking, for you to tell us, because Mr. Das, you can have access to the registry records.
Yes.
With regard to the infrastructure issues which are there, and therefore you can assist us in pointing out the whether anything more can be done to strengthen the infrastructure.
So you have a report from the registry
I'll
on
get
the
a report from the-
deficiencies in the infrastructure.
Exactly.
And then let the state know what is your opinion. We are not questioning the wisdom of the state. Then we'll expect the response from the state. Then we may involve other departments also. So let us have that. Then the state can respond that these are the deficiencies. We'll address this way, that way.
Look.
Ultimately, state will have to address this.
Doctor, can you observe in the order
that way?
to get, so that I can get a report from the registry with regard to the issue? Can you observe in
We'll
the?
pass an order.
Yes.
We'll pass
But,
an order. Yes, Mr. Nath, you wanted to submit something.
possibly the infrastructure, they will address as regard the JJBs, Milord.
JCBs.
JJBs. And Milord,
No,
here,
that only on the JJBs, not as a whole, because other part is being monitored by this committee and the state
yeah,
itself.
not. And Milord, here, the NHR Z I have indicated, there we have submitted report as regard 77 CCIs. Other Milord 16 or 17, it is under compilation. Report has already come. It is under compilation. On the next date, Milord, we'll place it before your lordship.
So inspection is complete.
Total 93 has been done. 77 we have indicated here. We have annexed here, and 16 is left, Milord. That will place it before your lordship. Overlap annexure F we have
But
indicated.
can we request you that because this reports which you have provided here,
Yeah, lordship.
from page 19 onwards,
Yes, Milord.
can you have a landscape printing so that we can, it's easier for us to read?
Correct.
This is too small.
Lordship. But in fact, we have a copy, Milord. We'll just make a copy and
We want a print like
lots
that.
of I'll make xerox and send it. I'll provide it. By today. Soft copy में नहीं गया ऐसा नहीं. Soft copy में नहीं गया ऐसा नहीं. We have given an overall view at NHRF, and NHRG are all the reports as regards 77. Milord.
Dr. Dekha, in the last order sheet, we have given the names of your officers present. We record the same thing, or any other officer are there?
One more officer is there, Milord.
Just-
3 and one more, Milord.
Okay.
She is member of ASCPCR, Milord. She has from the ASCPCR. She has come.
Okay.
Keep the details in a.
Yes, sir. Milord, we
It is,
have already.
and we are sorry that we had to wait in the gate today.
Milord, that at our level possibly, Milord.
No, whatever be, but the officer had to be waiting at the gate. We regret that. We'll see on the next date. On the next date, give the advance notice for them. Huh? Please give that those names in the advance so that
Yes, sir.
they can notify at the gate.
In fact, today court master has already allowed. We have given the name, he has allowed, and he has given his number also. But there is some miscommunication.
So that's
as-
okay. But
lot.
we'll see
Lot.
that
We'll give, we'll give,
that doesn't happen.
we'll give.
Because if it is given a day advance, then we also come to know about it.
Lot.
Ah.
In a day advance, we'll give. Lot. 18 I'm going to give. ना लगे तो
Uh, Heard Mr. N. Chaudhary, learned counsel for the Bachpan Bachao Andolan. We have these names here, huh? Except for Mr. P.P. Sharma, everyone will be there. There are two other names which will be added. Last order, 28/3/2024, first paragraph will be same. Next paragraph. Pursuant to order dated 28/3/2024, comma, the learned senior government advocate has produced before the court a bunch of documents along with a forwarding letter dated 24/6/2024 issued by the Secretary to the Government of Assam, Women and Child Development Department. Which, comma, which contains, comma, amongst others, comma, response of the order dated 10/10/2023 of this court in connection with PIL 60 of 2019. Minutes of the High Court Notified Committee's meeting held on 19/6/2024, as well as statement of district-wise submission of reports by the Guwahati High Court Notified Committee members. Full stop. It is projected that the committee members have carried out physical inspection in 93 childcare institutions. Most of the said institutions are run by the government, comma, NGO, which are operated through grant in aid, and NGO which are run by self-funding. Full stop. It is further projected in the said report that two childcare institutions have been derecognized, which are both in Kamrup Metropolitan District. The individual report of the childcare institution inspections are also enclosed. We appreciate the work done by the High Court notified committee in carrying out the inspection of 93 childcare institutions. How much is left out?
All are done. The report here we have compiled and given 70 in respect of 77. 16 are with us. Well, compilation is going on. We will submit it.
Inspection is complete.
Okay.
Reports complete in respect, reports submitted in respect of
93.
93.
93.
93. Well, compilation,
Rest are under compilation.
compilation has been done in respect of 77. We have annexed here. 16 are
Still.
compilation is going on.
Okay. Just clarify, 77 inspection reports are provided and it is submitted that 16 reports are under compilation and would be
But they have
presented on
given
the list.
report in form 46. We have made a compilation thereof and we have put here. Otherwise, the report committee has given in form number 46.
Okay, the report by the committee is under form number 40,
6.
Six.
In the last order, Lordship has indicated.
46.
In terms of this question.
What is it in terms of this court's order?
Paragraph 3 of the last order.
Next para, the no, not that para, same para. A copy of this said report is also furnished to the learned counsel for the High Court as well as Bachpan Bachao Andolan. Next para, the said respondents shall peruse the said report and may give their comments on the next date. To suggest if any further steps can be taken. Next para. In respect of paragraph 4 of the order dated 28/3/2024. In the first paragraph, you say that this takes care of the directions issued at paragraph 3 of the order dated 28/3/2024. Now, you see, in connection with the directions issued at paragraph 4 of the order dated 28/3/2024, comma, the learned senior government advocate has submitted that the State Child Protection Society has conducted one-day training program for social social workers.
Workers as well as the workers as well as the members of the JJB.
Okay, for social
Huh?
workers and members of the JJBs, which was conducted on
CWC. No, it was not
JJB and member chairperson of CWC.
CWC.
Child
and,
welfare.
and members and chairman of CWC, which was held on
in the page 1, in our response to page 1, paragraph number 3,
just tell us the date
10/10/23,
on 10/10/2023.
sorry. 10/10 in response to 10/10/23. That we have in the earlier report we
Done
have
on
given.
22nd and 23rd February 2024.
Yes.
It was earlier.
Another one previous, in the previous month, I think in December. My lord, that was submitted, the dates were submitted in the
In-
earlier response.
In last order we have
It was completed.
Oh, that is completed. Then notified.
yes, it is done.
That is
It is done.
Notified. 4 strikeout. In respect of
Paragraph 4, kindly indicate paragraph 4.
No, that is not an issue today because that was already completed.
that is already passed.
It is passed and Lordship has indicated in paragraph 4 of the last order.
Last one.
No, it's okay.
Lodge.
No, we do not
Lodge.
require that.
Lordship.
In respect of directions containing paragraph 5 and 6 of the order dated 28/3/2024, the London Senior Government Advocate has submitted that the draft rules have been finalized after the state level consultation. And as per his instructions, the draft rules would be placed before the government on 26/6/2024. Stop. It is also submitted that the child protection policy has also been drafted and
You will submit a draft rule tomorrow, or you have already submitted a
No,
draft rule
draft rule already we have done it to the government. They will submit it tomorrow.
tomorrow?
Yes.
this policy also will be submitted tomorrow.
Policy already submitted. It is with the government, my lord. Page 2, first paragraph, we have indicated that some changes are being made at government level. It is already submitted, my lord. Page 2, second paragraph.
Third paragraph.
The State Protection Society has submitted the draft child protection policy to the government for approval and notification. Some changes are being made at government level.
So already submitted.
It is submitted. It is with the government.
That will say child policy has already been, sorry, the draft child protection policy has already been submitted to the state. They are waiting. Approval and notification of the said policy at the earliest. So we hope and trust that both the draft rules as well as the draft child protection policy shall be finally notified by the appropriate government prior to the unique date of listing of this matter. Next matter. Respect of observations made in paragraph 7 and 8 of the order dated 28/3/2024. The learned senior government advocate has submitted that the Women and Child Development Department have approached the University of Guwahati from Department of Law and the Department of Law has submitted a project proposal for social audit of childcare institutions in Assam on 11/6/2024. What was the stage you said? They are approved.
Not.
This Guwahati University is approved.
Yes, my lord.
Okay.
It is approved. Already approved.
Okay. The said proposal has been
Guwahati
approved.
University, Sociology too.
And this work order will be issued, has been issued, no?
No, it is not issued. It will be issued shortly, madam. Because of financial implications are there, so some time has been taken.
There are certain financial
It took some time.
implications which should be addressed, and the work orders will be issued in at the earliest.
No, sure. It can be shortly will follow.
We request the senior government advocate to provide the work report with the status of the initiation of the status of the social audit program being undertaken by the state on the next date of the state.
Gotcha.
Next paragraph. With regard to observations made in paragraph 10 of the order dated 28/3/2024. Learned DHEI has submitted that there is a receipt of certain instructions from the Government of India. But he has asked for more clarification.
So in fact, they have given me what are the amounts released, but how the monitoring system? We are in touch, that is not.
In this regard, what is the time to put on record that as the Government of India we have to record that in our order dated 8/2/2024, paragraph 6, the court has recorded as follows. Quote this paragraph 6. Stop. Next. Next paragraph. Therefore, from the submissions made by the learned DIGI, it appears that he has been instructed only with regard to the status of the funds spent during the financial year 2021, 22 and 2022-2023, which is
23-24 has also been.
and as well as the year 2023-24. Full stop. Except for the last financial year's expenditure, the court has already taken note of the funds spent during the year 2020-21 TO2, 2022-23. Full stop. This next paragraph. This court is taking up the matter to see that the infrastructure which is proposed by the Government of India is actually created in the field level in the state of Assam. Stop. Therefore, the court is not interested to know only about the figures in respect of the money spent by the Union of India, but the intention of the court is to understand that the Government of India has recorded its satisfaction that the amount of expenditure incurred by them has led to the creation of infrastructure for which the money was intended. Full stop. Therefore, unless the Union of India cooperates with the court to provide the details of the the details of the infrastructure which for which the money was intended, and to also inform the court that they had recorded their satisfaction that the money money spent was well utilized. The responsibility of the Union of India would not end. Next, therefore, the Government of India, through its which department?
Women and child development.
Women and Child Development Department are put to notice that in the event they do not provide the learned DSGI and also do not file an affidavit in terms of in terms of paragraph 6 of order dated 8/2/2024 to bring on record the nature of facilities created and how they are monitoring that the funds provided by them are properly utilized. The court would be compelled to pass appropriate orders to ensure that the head of the department be personally present in court to respond to the court queries, for which appropriate orders would be passed on the next date. Full stop. The court expects that the Women and Child Development Department, Government of India, to take note of this order and comply and comply with the directions issued. Next paragraph. You just agree to a date, all of you.
My lord, may I make a small prayer, my lord? My lord, my learned friend otherwise has shared with us the summarized sheet of all these CCIs which has been inspected. The form 56, however, I am to understand that that is a very voluminous document that could not be shared online. May I request that my learned friend may provide both of us with hard copies of the same so that we can at least go through the same and assess the court in a better manner?
Instead of hard copies, you can give them soft copies. That will be more better.
Whichever is convenient to my learned.
Soft copy will be better. They can-
We'll give scan copy.
Soft copies will be better.
Yes,
because,
we'll
next paragraph.
give the scan copy.
As prayed for by N. Chaudhary, learned counsel for the Bachpan Bachao Andolan, the
Form 56.
the
46.
the detailed inspection report, maybe the state of Assam will share with the Bachpan Bachao Andolan soft copy of the inspection report. Next paragraph. We also permit the standing counsel for this court to obtain a report from the registrar within the judicial as secretary to the secretary to the High Court Juvenile Justice Committee, the report of infrastructure of the JJBs.
No, basically
Of
child
the,
friendly,
of the JJBs.
child friendly court and
We just say JJB.
JJBs.
Let them.
JJBs. First to enable him to give their inputs. Next paragraph. As agreed to by all sides. Oh,
But
let this matter be.
Okay.
Yes.
by first week of July, we'll hand over all the, we'll mail all the documents. Those are voluminous documents, we'll scan and send it.
When is that proposed date, next day?
7 days time is required for that. And in the first week of September, if Lordship takes up.
No, we have to do it early because there's another issue which is coming up.
Lordship.
That is, we are taking up on administrative side. There is stakeholders meet of the Supreme Court of India. You already, I think the state has been notified.
Okay.
You have got the notification by the Supreme Court of India about the dates fixed for stakeholders meet.
The department is like a-
26th, 27th of September. Before that, in fact, the state level consultation will also have to be done, preferably within the last week of August. And
We're doing it regular basis, yearly basis. Last year,
so, so in fact, we'll have to have this bench before that.
Then the second,
We expect Mr. Nath and Madam you also. Before we have our stakeholders meeting, we have our policies and draft. Because this will be question in the All India conference also. Then who are the states which are having these policies? We do not want to have a sorry face for the state also.
So since we are dealing with that in the administrative side, we are not incorporating this in the order. But you'll have to take care that these deadlines are there.
Yes, yes. But definitely we'll convey and we'll try to impress upon them so that it happens. 20 तारीख में लोग या 220 अगस्त 20 में ना हम तो না আমার এই আমাদের যে সোশিয়োলজি স্টার্ট করব রিপোর্টটা দেব প্রসেস তো ইনস্পেক্টরটা কি হয় No, 20 August, 20th of August. Okay.
We are proposing subject to how you agree to, whether you agree to it.
Not.
We commencing 22 this dates of 20 to 22 August.
Yes, yes.
This will be more convenient for us because next we will have that stakeholders meeting and then
My friend has suggested 22nd.
22nd.
We have
22nd is okay?
22nd. Fine.
Okay.
Because I have to get the status report of the social audit also. That's why I have.
20, this one 22/8/2024.
JJB is totally available.
Next paragraph.
Your office service like a separate office. I will share something like that.
The Chief Security Officer on downloaded copy of this order being produced shall permit the officers of the state government to enter into the court premises on the next date of listing. And before that, you write where we have stated that the government advocate, senior government advocate has produced instructions dated 24/6/2024. There you write, the said forwarding letter along with the enclosures thereto are made part of record.
Follow.
Look, subject to permission of your lordship's lordship said, subject to approval of your lordship's lordship has recorded that I'll get the instructions with regard to infrastructure of JJBs. Can the child friendly code and VWDC also be included later on? Fine.
It is already there.
It's already,
You will find it.
no, it's there already, my lord, but updated instruction I would have, fine, man.
No, that's the only updated instructions we have is a month old.
Fine,
We have
in the, yes,
We've already seen that.
my, fine.
22nd of August.
Anything we have left out? No.
No.
The other? We thank you, but we'll need something more. Item 3. Mr. Nath, just wait for some time. This item 3 also, this issue
Yes.
which the Mr.
So I'm appearing in that case also. Item 3.
Mr. Kumar was referring to. Now Mr. Kumar has said that this affidavit you have filed is satisfactory. So what should we, what sort of order we should pass next?
Lordship, satisfactory, what he was trying to say was that what the picture that we have projected in the affidavit is correct and
Please come over
it
this
is,
side.
what he was trying to apprise the Lordships was that the affidavit now projects the correct figure or the correct picture of what is actually happening in the Doboka temporary shelter home. Lordship, the entire matter was taken up by this honorable court because of the fact that certain children had fallen sick and they at that point of time no assistance was given to them. Now, subsequently, Your Lordships, this honorable court, in its own wisdom, had taken up the entire matter in a more broader manner and had asked us to give us a picture of how many shelter homes are there in the entire state of Assam, to which we had filed a detailed affidavit on the last occasion, before I had filed this affidavit, Your Lordships. And thereafter, this affidavit has been filed only to bring on record the exact picture insofar as Doboka is concerned. Now, if my learned friend, if Your Lordship finds that steps are being taken, then perhaps the PIL can be closed. But in my respectful submission, the picture which is being projected is a very dismal picture. And to be very fair as an officer of the court, perhaps more action is required from Your Lordship's end to ensure that these people who are staying in these shelter homes are rehabilitated in a proper manner, Your Lordships. I'm not very sure why the matters have been tagged together. Also, the submission was made on behalf of the.
In fact, since the issue relating to children is involved in this case, and the other PIL is also relating to the children, right of the children, so that is why this particular PIL item number 3 has been tagged with the other two matters. Well, in fact, we have filed our affidavit in the matter. There is actually, well, there is no shelter home as such at Doboka.
बोलो तुम भी मैं क्या बोलूंगा तो मैं क्या
Whatever drinking water and all these things they have already provided. In fact, they have been rehabilitated, but the person is not going to the place which which is given to them.
এটা মোস্ট ইম্পর্টেন্ট রিহ্যাবিলিটেট করলে এটা জানা লাগবে যদি not willing to go only, no? Nothing willing, sir.
Okay, let's take it up next.
Lordships.
That will be passed in the, we propose to pass orders in the presence of Mr. BD, BD Kumar.
So Lordships are fixing on the same date, 22nd of August.
Same.
Ah, yes, same.
Yes, Lordships.
Also, it's a representative. Does this matter on same date, 22, 8, 2024?
22/8.
In the meantime, think over how, is there any scope? We'll deliberate on that.
Lordships,
that day.
What has happened? Just for a moment. Well, there was a eviction drive
Oh,
from forest area. Some persons, their encroachers, they were evicted. At the time of eviction, they came to that particular place and they took temporary shelter homes. There is no shelter home from the government. Lord. In fact, after that, the persons have already been given land and they have been already rehabilitation has already been done. But some of the families, they are still living there.
They're refusing to go from there to the place which has been provided by the government. And they have created this temporary shelter home on their own. So, and it was in that shelter home that these children had fallen sick.
But
So the
the
issue,
principal issue is more or less settled.
settled.
insofar as the eviction drive was concerned, there was another PIL which was closed by this honorable court.
Yes.
They have been rehabilitated. That was also another PIL also closed by this honorable court, which is all a part of the records of the amicus curiae report, your lordships. And so what requires
So
to be done is
whatever, we'll take a call on the next day
On the
in
next day.
presence of Mr. BD.
Yes.
That will be
lordships,
better.
that would be best perhaps.
You also give your suggestion because
Lordships, the only
the nature
suggestion
of orders we have to pass.
Pass.
Be prepared on that.
the requirement was for the government to have rehabilitated them at some particular place, which the government is saying that they have done it. So it is now incumbent upon their families to move themselves from that particular area and get to move to the other place. If
Okay, let us
Let's
see
see
the
what-
response of the amicus.
Well, in the meantime, Mr. Nath, you can also ask your officers to get the
See the exact
status
status.
report
status.
as to whether they are interested or they don't want that land and be rehabilitated. So have a clarity on that also. So day before, please inform the court master so that The
Will-
entry can be seamless.
Lordship.
Because I'm praying that the matter be taken up after the vacations.
Okay. All sides are represented on the prayer made by learned counsel for the petitioner, placed after ensuing summer vacation.
Oh, there's an interim order.
Okay, interim order passed today, stands extended to the next date of listing.
I'm deeply aware.
Malata, I beg to mention item number 25 of today's list. Well, this matter, your lordship may not be taken up. Item 25.
Item
25.
25.
Yes,
Oh, acha, 25.
that's RS Khan matter.
Oh, okay. 25. List the matter before any other bench without me.
Much appreciated.
May I listen? I beg to mention item number 10 matter. Mr. M. Swiggy has certificately instructed me, well, he has some difficulties today matter. Can you detail your lordship for the sir?
Okay, it goes after vacation. Okay. On the prayer made by learned counsel for the petitioner, just in the motion column after ensuing summer vacation.
Deep blues.
I beg to mention item number 12, Lordship. 12, Lordship, item number
12.
12. Matter may be adjourned for the day, Lordship. I could not prepare for our Lordship.
Okay, it goes after vacation.
Many day, Lordship.
The same order. 12.
Wait, please, Lordship. Lordship, item number 4 may kindly be adjourned for that date.
Oh, it goes after vacation.
Lordship.
Same order. 4.
Obliged.
Lordship, I beg to mention item number 49, Lordship. Can take up the matter after vacation, Lordship.
After vacation is paid for by learned counsel for the petitioner.
May it please your Lordship. Lordship, in item number 42, we have filed an objection, Lordship. That may be called for.
Yes.
May I please, your Lordship. I beg to mention item number 20 and 21.
Item
20 and 21. This matter may be taken up after vacation.
2021. Okay, you have informed the other side.
Other side is the
So there are so many lawyers from the other side.
I will
Wait for a
inform
turn. You renew the prayer when the matter reaches. Next.
Wait, lordship. Yeah, beg to mention item number 5, lordship. In this matter, lordship, I filed one IF for implement of party yesterday, lordship. So that matter is not available before this court. So maybe taken up after the vacation, lordship.
Okay, list after ensuing summer vacation as paid for by learned counsel for the petitioner. The registry shall tag interlocutory application filed in the matter with record.
Yes, sir.
Obliged.
I beg to mention item number 6, your Lordship.
6.
Yes, your Lordship. We need to file an IA for implement of new parties, your Lordship.
Okay. List after ensuing vacation as paid for summer vacation is paid for by learned counsel for the petitioner. You have filed or you want to file?
Want to file, your Lordship.
Oh, okay. So as to enable the petitioner to file impleading application. Okay.
Obliged.
May I please, your Lordship, I beg to mention item number 50. Kindly,
Item 58.
50, subli,
50 or 58?
50.
50.
Kindly allow the withdrawal, madam.
Withdraw application. Okay. Upon instructions, Mr.
A Malik,
Your name?
A Malik, Abdul Malik. On behalf of A.T. Sarkar.
on behalf of the ACC counsel for the petition seeks to withdraw this contempt petition. Prayer is allowed. Matter is dismissed from withdrawal. Okay.
Item 1 for withdrawal.
Applicants have filed a IA, read petitioner number 6 and 12. They want to withdraw their names, my lord, from the read petition. Six and 12. Dipti Bora and Janti Bora. Yes, who's for the petitioner? Read petition? For the read petition. Previously he is for the read petition and he has already given no objection to me, madam. So he is also there. Okay. Okay. But Mr. D.K. Naplan, counsel for the applicant. So the applicants are petitioner numbers 6 and 12 in the connected WPC 1256 of 2024. Well, first off, the applicants applicants have paid for allowing them to withdraw the name as petitioners in the connected WPC 1256 of 2024. Mr. A.D. Chaudhary, counsel for the writ petitioners, has submitted that he has given no objection to the present set of counsel for the applicants. Next one, Mr. D. Nath, and its senior government advocate.
For respondent number 2, 3, 4, and 5.
Except is present on behalf of respondent numbers 2 to 5.
Lodged.
CGC, who is there? Ms. B. Sharma and CGC is present for respondent number 1. So the prayer is allowed. The prayer is allowed. The name of petitioner numbers 6 and 12 in the connected writ petition is allowed to be deleted. The main writ petition also right. Mr. A.D. Chaudhary and counsel for the petitioners. Ms. B. Sharma and CEC for the respondent number 1 and Mr. D. Nath and senior government advocate for respondent numbers 2 to 5. Next, review of order passed today in the connected interlocutory application for the names of petitioner numbers 6 and 12 have been deleted without affecting the seriatim of the parties in the of the petitioners in the petition. Public.
There is an interim order in the main petition.
Well, in the main case, my lord, there is a stay going on. We have some urgency, my lord, a selection process has been stayed. A selection process has been stayed in the main case. I pray for a date, my lord. Now, my lord, before the vacation, possibly no time is available. After the vacation, kindly give us a date, my lord.
Did the next matter, the learned senior advocate has senior government advocate has submitted that there's some urgency in the matter as because of the interim order of the court, the appointments will not be made.
My lord.
list on
But if possible on 20, can it be on 22nd or 23rd, July?
22nd, we can fix
Lot.
22nd July
Lot.
2024. Interim of the past 5 years stands extended till the next date of the state.
I dispose.
Item 2,
Wait, please.
Yes, Mr. Bhagwati.
Lordship, item number 2 and 3, Lordship, both are escort bank matters. All these matters are taken up by Honorable Justice A.B. Sodhuri, Lordship. Today also, a lot of matters are there, Lordship. 10, 12 matters are there, Lordship. So they may come up together, Lordship. Same order, Lordship.
I'm just adjourning it. You make a mention before the registry.
Lordship,
Or make a mention before that court. With a mention.
Lordship.
When Mr. B.K. Bhagwati ran counsel for the petitioner, he praised that the matter be passed over for the day. So prayer is allowed. The matter is passed over for the day. You make a mention to all.
Both 2 and 3, Lordship.
2 and 3, same.
M. Bhagwati, Lordship.
Same Bhagwati.
item 7,
So notice. Yes. Had Mr. Z saying on counsel for the petitioner agreed by the order of dismissal from service and the appellate order dismissing the appeal filed by the petitioner are assailed in this writ petition filed under Article 226 of the Constitution of India. You should notice a motion returnable in 4 weeks. Mr. D.P. Baral and as standing counsel for the Health Department accepts notice on behalf of all the respondents. First, requisite extra copies of the writ petition be served on him in course of the day. Next, this after 4 weeks.
item 8,
Yes, you have got instructions.
Your Lordship, they never supplied us any extra copies also. We never
So
got.
there was no order also to give you extra copies.
Lordship, we did not send any because we did not get any extra copies. Because that's the norm we follow otherwise. Because there are many respondents here. Lordship. 4 respondents. And Mangolda Municipal Board notice has to go to the Mangolda Municipal Board. They are the person who will be able to actually inform us as to what would be the what is the status. Maybe the appeal may be disposed also. That's why the petitioners are not appearing. Maybe the appeal which is pending before the director of insurance, maybe it has been disposed of. But you can list it on, I'll inform the petitioner about his number in this writ petition. I'll inform the petitioner to, your lordship may take it up day after tomorrow, your lordship,
No, we can't.
or tomorrow for that matter.
It has to come after vacation.
Eight. Extra copy on the end. Appeal to. Your lordship, my inner friend, he has appeared now.
Yes.
In last occasion, instruction was called for.
You did not give him copies of the petition. How will you get instructions? You have a copy of that act, Assam Employees Parent Responsibility. You have a copy of that act?
Yes.
Pass it on. Please tell us, this act is applicable for the state government employees. Now, it shows that this act has been adopted by the Mangalore Municipal Board. Has it been adopted by the this board? Board is not the state government.
My lord, but undertaking government, some debts are collected by them and proportion person to be submitted to.
No, we can't presume. Board is not a state government. Under the Assam Municipal Act, board is not a state government. It's an autonomous body.
Grant in
aid is provided. Grant in aid is provided, but it's not a state government. It's not a state government, your reputation would not be maintainable. But yes, for one party it will be maintainable. The appeal has been filed before the Director of Municipal Administration.
That too, your lordship, they have actually sent this particular appeal by registered post. This whole appeal was sent by registered post. So I don't know whether they have actually received it or not. That is the problem, your lordship. Let me get instructions as to whether any kind of appeal is pending.
On the next date of listing, the counsel for the petitioner shall provide a postal track report of the appeal being sent to the appellate authority. First off, listed in the motion column after the ensuing summer vacation. You provide us with a track report of service.
Annexure number 7.
They will know. We are returning your act.
Yes.
That's it. Vacation. Did the
Master place.
Obliged.
You make a mention if it is not listed.
Item 11,
No, 9. Item 9.
Yes, lordship, as per the earlier order, we exceeded. You have impeded a party, lordship. What I just finished.
You have impeded?
We did water user committee, lordship.
Okay. You should notice then. Let me say, counsel for the petitioner. The petitioner claims that he is working as a labor under the Hope Kaladuba, KALADUBA, PWSS under the Jal Jeevan Mission, under the PhD department. Full stop. The said appointment is required to be made by the users committee. So the petitioner appears that His services may be discontinued to induct another person under in his place. And accordingly, this writ petition has been filed under Article 226 of the Constitution of India. If you notice, including notice of the prayer for interim relief returnable in 4 weeks. Requisite extra copies of the requisite extra copies of the writ petition is served on the learned state and departmental counsel in course of the day. This sort of holds.
Obliged, your lordship.
Eleven,
Yeah.
Oh, so, you just record her name, Miss. We forgot to record your name.
MSM Kalita, your lordship.
M. Krita, PhD.
Yes, sir.
But you represent all the respondents,
From 1 to 5.
1 to 5. Okay.
That will.
Yes.
I have newly implemented my respond number 8. Earlier occasion, your lordship was pleased to dispose of the matter, but this he was not there. He has responded 8.
Okay. For Mr. A.M. Borvial and counsel for the petitioner. Also heard Ms. M. Kalita and standing counsel for the PHE, representing respondent numbers 1, 5, and 6.
No, lordship, only 1 and 5. 6 is BTAD.
1 and 5.
Yes.
Okay. Mr. C. Barwa, standing counsel for the respondent number 4. Finance of Mr. R. Barpujari, Leonard, standing counsel for the respondent numbers 2 and 7. And Mr. C. Hazarika, and government advocate appearing for respondent number 3. Who is appearing for 6 then?
6 and 8.
6 is BTC.
BTC.
So,
Record the name of Mr. B. Chaudhary. He is there in the folder.
okay. Mr. B. Chaudhary, the standing counsel for the BTC, representing respondent number 6 and newly implemented respondent number 8. So the petitioner claims that he was initially appointed as a muster roll worker under the Executive Engineer PHE Tangla Division, and his service was regularized as Khalasi with effect from 22/7/2005. The petitioner had superannuated on 30/11/2016 on attaining the age of 60 years. And as he's and as the petitioner claims to have continuously served the department for 25 years, 8 months, 18 days. With his regular service as 11 years, 4 months, 8 days. Petitioner claims entitled to regular pension. First, accordingly, by filing this petition under Article 226 of the Constitution of India, the petitioner is paying for a regular pension. And till finalization of the regular pension, he also pays for a provisional pension. Expiration notice returnable in 4 weeks. Requisite extra copies of the petition be served on the state and department counsel in course of the day. Next, pendency of the writ petition shall not be a bar for the respondent number 8, sorry, 6 and 8 to examine the claim of the petitioner. Let's start off all this.
Obliged, your lordship.
Item 13,
Obliged.
Wait, please, my lord. Wait, please, my lord.
Nice.
My-
This on what basis you are challenging the appointment of the private respondents?
My lord, on the basis of seniority, my lord, on the count of seniority, my seniority is more to them, my lord. And experience wise.
That perhaps, my lords, is
How did you, Mr. Chaudhary, calculate the benchmark?
as per the experience, the documents pertaining to the experience as provided before the committee, my lords. Now, again, this is a provisional list, my lords, that was prepared. And the private respondents who've been arrayed as parties here, my lords. It is not a case wherein it's because of their names being inserted in the provisional list, they have been left out. If they are eligible, my lord, they'll also be included in the list. It is not at the cost of the private respondents. My lord. So there is no requirement of as such, my lord. Whether or not this list is the final one, my lords, I'll get that instruction. Because it is a provisional list, my lord. It says it's a provisional list. And the order in question, my lord, the enhancement order, page 84, my lords.
83, yes.
Yes, starts at 83, my lords, page 84. It says in the interest of work, a committee is hereby constituted with the following members to examine any complaint/petition if arises regarding inclusion or deletion of any name in the provisional list of outsourced workers. So there is already a committee, my lords.
Where is your representation?
My lord, at page, my lord, 95, my lord.
I hope you are famous like the leaders of the political parties or or any other big names we know. I hope you are that famous. I hope the petitioners are famous like various movie stars, various leaders, political leaders. Because once you say a name, X, everybody will understand that X is so and so. Come to page 96. Your name is Tankeshwar Pegu. Now, who on earth would know Tankeshwar Pegu? Had it been some superstar like Amitabh Bachchan, I would have known. Now, you don't give any particulars. You want their names to be regularized. You just give the name Tankeshwar Pegu, Ranju Mili. How the PDCL authorities will find out these people unless they are famous? Please tell us how do you assess your performance just by the name Rajiv? And if I am to find out Rajiv, I won't have any means to do it and to exclude your name. Because in this court also we have more than 1,000 employees. If somebody comes and tells me, even my secretary comes and tells me my name is X, unless she gives me a description of her designation, I may not even recognize her. It says that please include the experienced persons in the list. You don't even say that we are experienced and our names should be included. Look at your representation at page 95. However, the complaint were delayed because of the busy departmental work. Therefore, it is necessary to take appropriate action. It includes the name of qualified and experienced person in the list. Now, please tell us how to work out. How do you expect that this representation of yours will be acted? How many employees are there? People like you, how many are there in the APDCL?
There'll be thousands of employees.
There will be in thousands. So please tell us how to work out.
Minor, may I read the relevant portion, minor? If this honorable court allows.
You just issue notice, you take
Minor.
care of it. Mr. D. Mehdi, counsel for the petitioner, and Mr. B. Chaudhary, done as standing counsel for the APDCA. Expiration notice motion returnable in 4 weeks. Requisite extra copies of the petition be served on the learned standing counsel for the petition in course of the day. Next, pendency of the reflection shall not be a bar for the respondent authorities to examine the claim of the petitioner. To address the representation submitted by the petitioner dated 16/4/2024 within bracket annexure 5. List after 4 weeks.
There are private respondents also.
There are private.
Oh, it's private respondents. Okay. The
7
petitioner
to
shall take
20.
steps within 2 days for service of notice on the private respondent numbers
7 to 20.
Huh?
7 to 20.
7 to 20
From 7 to 20.
by registered post with ED. Requisite extra copies. The registered post with ED. The counsel for the petitioner is permitted to collect the postal receipt number and submit postal track report prior to the next date of listing. Seven to 19. Private is 7 to 19. Okay.
It's 20 actually, madam.
I don't know. There are 219.
There are 219.
Then Yes, item 14.
Deeply obliged, my lord.
May it please your lordship. My lord, petitioner was enrolled in the year 2008, my lord. In the year 2017, my lord, when he was availing his earned leave, my lord, he was supposed to join his duty on 18th of January, my lord, but he joined on 19, my lord. There is 1 or 2 days late, my lord. For that reason, my lord, without any inquiry, without hearing the petitioner, my lord, he was given rigorous imprisonment, and my lord, first rating entry was given, my lord. Second occasion, my lord, when he was availing the married accommodation, my lord, he was along with his wife with 6-month-old baby, my lord. He was ordered to vacate his quarter. He prayed some time, my lord. For that reason, my lord, he was arrested and physically and mentally tortured and given second rating entry. On third occasion, my lord, being an occasion in the year 2019, in 2021, they have given third rating entry. So my prayer before your lordship, my lord, every rating entry was given without hearing, without giving an opportunity or proper trial, my lord. So now his mental condition is not good, my lord. He doesn't, he is at home, my lord, at present. And my lord, he doesn't want to work under this, my lord, respondent. He want to work under, my lord, headquarter, my lord. So his wife said one representation saying that, my lord, my husband is not good, my lord, his mental condition, he want to join under the headquarter general. And every rating entry was given without any inquiry. So, my lord, and they have not followed the proper procedure also. I have annexed, my lord, the rule also. Wife, my lord, given representation, and one legal notice was also given, my lord. They have not replied, my lord. So my humble prayer before your lord,
will issue a notice.
issue a notice.
Okay.
And my lord, one small prayer, my lord, pendency shall not be a bar.
Pendency shall not be a bar for.
To consider my prayer, my lord.
Ms. S. Boran and counsel for the petitioner, as well as Mr. A.R. Adhikari, learned,
MR, my lord. MR Adhikari.
MR Adhikari, learned, CGC appealing for the respondents. But against this Radiant case, you are not supposed to file a departmental appeal?
My lord, they have given me warning, my lord, saying that if you incur 4, my lord, will discharge you. That's why, as my mental condition is not good, my wife has given representation one after another, my lord.
No, but for these adverse entries,
My
you
lord,
have your own judicial system.
yes. That's why, my lord, my wife has submitted representation and on legal notice.
No, you want your entries to be red entries to be removed. Your wife will have no necessity to make appeal on your behalf when you are an able-bodied man.
Yes, my lord, he was, my lord, assaulted physically, mentally in the custody, my lord. He developed a fear in his mind, my lord. That's why, my lord. My lord,
No, it's why your wife has given a represent, that's not the question. The question is whether in the department you have a appellate provision against the adverse entries made in your ACR. You are under which force? Assam Rifles.
yes, my lord.
Is it Assam Rifles Act? Is it Assam Rifles Act? Central Act. A. Assam Rifles Act.
But can it be a true, my lord? Even I want to go through the provisions because just now, my lord, I was informed that, my lord, this matter has been allotted to me. So I could not go through the provisions. Section 2, number. Parliamentary procedures, my hand. Assam papers.
You have a copy of the rules? Just pass on. Give us that book. This punishment of infringement is under which provision?
Section 139, can you see? 139.
No, no. It can't be because this is a power exercised by the commandant.
First was.
The commandant has a power to put him into prison.
My lord, the first was given under section 26B. 26B.
26B.
Second was given 26(2).
No, no, in this Assam Rifles, there's a power of the commandant to impose certain punishments. That is not appealable.
Kindly see Annex 2, page 22. They have given.
Page 22.
Yes, my lord. They have given a chart, my lord. Left hand side, they have given the section. 2 days absent first.
No, there's something wrong. You're charged under 26B.
Yes, sir.
Then this proceeding has to be before the Assam Rifles Court.
That's why, my lord, I am before your lordship.
Where is the order of punishment?
The annex side too, my lord. Page 22. Here it is written, my
To
lord.
suffer imprisonment for 3 days by commandant. That's what I'm saying. The commandant has a power to do it.
But they have to follow the procedure, my lord.
No, if it is commandant, then it's not required to follow.
I have annexed the rule also, my lord. Page 34, my lord.
It's the word obvious. Ah, yes, now it is clear. This is the 61 says punishment otherwise than by Assam Rifles Court. Then 62 is minor punishments. Minor punishments is something which the commandant can give and which is not otherwise appealable. So it does not go to the Assam Rifles Court. And then we have, when you have suffered a punishment on 18th June 2021, now let to demonstrate that after 4 years, why, after 3 years, why your writ petition will be admitted.
My contention is that, my lord, they have not followed the rule before giving me, I have not
You
been.
tell us, you see, you should have been armed with this rules. You don't search for it. I have to search for it and find it out that it is otherwise permissible. If it is permissible, then why after 3 years we'll entertain a writ petition?
Last was given in 2021, my lord.
Yes, I am not supposed to read, but still you are making me read. Therefore, you'll have to give answers.
Tomorrow, my lord.
No, not tomorrow. It goes after vacation. You tell us, because you see, even after that, even without that, we can dismiss it. You see 61. And you see this cases of armed forces you do regularly. I take up once in a blue moon. Last matter I heard was when? Last year. So after a year, I am taking up this Assam Rifles matter. And I have some retention of that there is a provision where a commandant can give punishment. And it is not a punishment for with the court, by the court. So you see 61, now come to 62. So if that is the scheme, and you have accepted the punishment for 3 years. Now please tell us what is a good reason for admitting your appeal and issuing a notice.
Then, my lord, after vacation.
Next time, be prepared. Don't wait for the court to ask another question and then you say, again take an adjournment and prepare yourself. Correct? Don't do that. Because once we spend time, then we have to be harsh. Had we got your assistance, then that's another thing. But once you don't assist and we have to find out, then why should we take a liberal view? On the prayer made by the counsel for the petitioner, list after ensuing summer vacation. Mr. M.R. Adhikari and the CGC is present. Yes, Mr. Pathak, we see you here.
2 minutes. That, that compulsory retirement.
Unheard matter.
Oh, actually.
Supplement.
I will take not more than 2 or 3 minutes.
Okay. We resume after.
My lord, at your convenience.
Material lawsuit.
You're claiming new pension rules.
My lord, apart from that, my lord, they have adjusted our services against, my lord, the post of tutor. Whereas, my lord, we were appointed in the year 1995 itself against regular vacancy. Pursuant to selection process, that selection list has been, my lord, came out successfully, my lord, but in a judicial scrutiny by this honorable court. And pursuant to selection, if they were appointed in against regular post, their salaries should have been paid on regular basis, my lord, instead of paying the fixed amount for against tutor. That is the grievance of the petitioners, my lord. So at this stage, lordship may issue notice, my lord. Let the authority respond, my lord.
Okay. Heard Mr. Sekel and counsel for the petitioners. Also heard
S4.
Mr. S. Kumar, Leonard, standing counsel for the school education department, representing respondent numbers 1,
1, 3 and 4, lordship.
2, 1, 3 and 4. And Mr. Arbor Pujari, Leonard, standing counsel for the finance department, representing respondent numbers 2 and 5.
2 and 5.
Claiming common cause of action, the present writ petition has been filed under Article 226 of the Constitution of India, whether the petitioners are paying for area salary from 31/1/1997 to 31/10/2020, along with all service benefit that would have accrued to the petitioners, including the pension under the old pension scheme. Next. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the London State and Department Council in course of the day. Then Department Council in course of the day. Next, the pendency of the writ petition shall not be a bar for the which respondent will consider
Education department, my lord.
examine. No, which officer?
My lord, director, my lord.
Director. The shall not be bar for the director.
Elementary education.
Elementary education assigned within the correspondent number 3 to examine the claim of the petitioners. Okay.
My lord.
Upgraded item 51.
Before my senior friend submit, my lord, just to clarification, my lord, that gazette notification where it has been authorized, the AGM also, either general manager also can sign the affidavit and other document. That is gazette notification is dated 6/6/2006.
So he's not questioning your power to sign.
Actually, I am misunderstood. I am not questioning their power to file.
He's selling the affidavit on the ground that he could not have personal knowledge.
He is not saying from the personal knowledge. He is saying the knowledge
Just
gathered
you
from
give
that
your
we can
response to it.
rectify that affidavit, my lord.
I am on my reply argument. I will not take up this point also for the time being.
And my lord, another thing, my lord. That judgment we have submitted of Mahabir Singh of relating to Food Corporation of India from Punjab and Haryana High Court. That was the petitioners were all holding the post of the manager. So they were the category two officer. That was also a selection post, and their promotion is also on the basis of seniority, come fitness, my lord. Only this clarification. And further, my lord, then your lordship had asked whether how much benefit he has received, terminal benefit, my lord. On my lord,
That judgment, Mahavir Singh, in what context you are making that submission?
no, on last occasion we submitted that they were all of category 1, but that is not the fact. In fact, they were the category 2 post manager, and it's being a selection post, my lord, their promotion is also the seniority come fitness basis. So the principal will apply, my lord, for compulsory retirement.
Seniority come merit.
Fitness, man. Seniority come
Seniority come fitness.
fitness. And against that judgment, they have approached the Honorable Supreme Court, my lord, and it was listed on 22/5/2024. But those petitioners,
Just a moment. Yes.
they approached the in SLP, my lord, before the Honorable Supreme Court. It was listed on 22/5/2024, but on that day they have taken time, and it has been refixed on 25/7/2024, my lord. We are just giving the printout, my lord, from computer, my lord. Then regarding, my lord, the benefit the petitioner has received, my lord. My lord, the petitioner has received the 33 lakhs 3,998, and CPF is pending. He has not yet filed an application for withdrawing that amount, my lord. That is 91,53,062, my lord.
Just a moment. What is the amount withdrawn?
Amount withdrawn is 33 lakhs 03,998. 33 lakhs 3,998, my lord.
33 lakh.
3,998. That is my
What is this amount?
that is gratuity, then earned leave, and 3 months salary in lieu of the notice, my lord.
The 3 months payment in lieu of notice.
Yes, my lord. And the contributory provident fund, he has not yet withdrawn, my lord. That amounts to 91 lakhs 53,000.
Yeah, just a moment. Just a moment. Yes, please give the amount.
Contributory fund amount is, my lord, 91 lakhs 53,062.
This is contributory.
Provident fund, my lord. The petitioner has not yet withdrawn, my lord. So, my lord, the total comes to
Okay.
total comes to, my lord, 1,24 lakhs 57,060. My lord, my affidavit, just one. Affidavit in opposition on the last occasion, we have said that we have wrongly mentioned fair, my lord, at page 110, paragraph 20. It is fair, my lord. That is fair for the 3 months. It is written there October to 2009. That was fair grading for 3 months, my lord. That is okay, my lord. So, my lord, this much only.
Okay. You remember the question I asked on the last occasion? You told you that it got, somebody was annoyed because of this question posed as to what was the income.
Oh, yes,
You know that?
I remember. I remember. My lord, may I begin?
In fact, I was thinking why I went wrong, why I referred to Mr. Singh to be there. He was not there. Mr. P.K. Roy was there. Oh,
Work, that they're called some work sirs or something, some levels. May I begin?
yes.
My lord, here the FCI, Food Corporation of India, they carried out an all India exercise. The Food Corporation of India, they carried out an all India exercise to weed out the dead woods after assessment of their vigilance and administrative reports. And as my learned senior colleague, Aditya submitted, there are almost 320 or 23 officers were taken together, 320 and 23 officers, these are the singled out. Now, so for this case is concerned, I'll come to the Punjab case little later, but I will not take more than 3 minutes of your lordship. At page para 27, at page 106 and 107 of the affidavit in opposition, they have identified the black spots in my 22 years of career graph. I'll have to save your lordship's valuable time.
No.
Because I think because there are other. These are the black spots in my career graph. I have quoted it from para 27 of page of affidavit. Number 1 black spot was because of a complaint, I was transferred on 21/10/2009. This is my black spot. Second black spot, charge sheet dated 21/10/2010 resulted in penalty of censure. Number 3, because of an email of the then GMN who was above me, I was transferred from Karnataka to state of Tamil Nadu. Next, because of a memo dated 8/8/2011, I was warned to be more careful as a lordship. Next, because of a so-cause notice dated 26/2008 for not lodging FIR against truck driver, I was given warning. Next was because of a memo dated 2012 for not attending zonal office meetings, there was no penalty. I was given a letter. Charge sheet dated 1/10/2015, all the charges were dropped. Number 8, these are the pinpointed black spots in my career graph. Charge sheet dated 3/2/2016 issued. Writ petitioner was imposed penalty of reduction of pay scale by 2 stages for a period of 1 year. Later on appeal, penalty modified with reduction of pay scale by 1 stage for a period of 1 year. Now, my lord, if your lordship comes to page number 15 of the writ petition for a while, E, there is a statement of facts. My lord, I will not take your lordship, just let me submit it like this, my lord, 1 sentence, because lordship, there is a statement of fact that out of 320, that lot, all India lot, there are many people who are having GM, not people, general managers. They are having penalties as well as proceedings going on. This is a statement of fact not denied in the affidavit in opposition. Because they took a all India exercise to weed out the deadwood. And I have been identified as a deadwood, whereas, because in your lordship judgment also, Guwahati High Court judgment, I will come to it, the arbitrariness and the persons who are with heavy penalties and proceedings going out, they are allowed to continue. Now, at the same time, since I was promoted in 2019, no departmental inquiry or proceedings are pending against me. Now, why in 2019? Well, that was the time when I was promoted. Now, if I was promoted, your lordship, last occasion has gone through, under clause 7, then they should be visibly meticulous. That is the language used for the last few years. Visible meticulousness is not shown. They are taking the period from 2005 or 6. But since there is no departmental proceedings pending ever since I was promoted, they have not even disclosed, subject to corrections what transpires in the records, that visible meticulousness about this period. What is, in fact, the apex court also said that if that is the sir, what is the last period? Now, in 15D of the writ petition, I have taken another point, my lord. Your lordship will remember in clause 12, there are, in the same sentence, there are 2 words. The review committee's report, if my recollection is correct, shall be placed before the appointing authority, who shall consider, this is one aspect, and approve. Merely saying that approve, because page number 64 and page number 81 of the impugned letters do not reflect or make a whisper of it that he has considered it. This, my lord, the records will reveal, because this is another point that I have taken in the writ petition. Now, in my reply, concluding reply, my lord, I will also take your lordship to para 20 of the affidavit in reply. The other day it was argued that what can be taken as an adverse entry. Now in para 20 affidavit in reply, your lordship will, page number 160, that has been spelled out by Government of India notification as well as their circular, classifying that these are to be noted in the APANR. If it is not there, then no other subjective comment will make a difference. Because basically these circulars were issued so that to ensure that there is an objective consideration for a subjective satisfaction. Now, my lord, I am coming to your lordship's judgment, that Guwahati High Court judgment. I have gone through it, my lord. Other day, I am extremely sorry that I failed in my duty to go through that judgment. In that particular case, your lordship, our High Court, has relied on that Das, Vaikuntha Das case, possibly in paragraph 12. Your lordship has also quoted paragraph 30 of Vaikuntha Das case. I am also relying, because why I am relying, my lord, in one sentence I will conclude, because there are paragraph 34, your lordship has relied on and has passed that it's not an order of compulsory retirement, per se is not an order of punishment. There the person wanted to retire, but later on it was converted to, your lordship said it's not an order of, per se it's not an order of punishment. Here your lordship has relied on paragraph 34 of Vaikuntha Das case. In lordship judgment is paragraph 12. In paragraph 34, in Roman 3 and Roman 4, it is specifically laid down by the apex court that if it transpires from the records placed before your lordship, that there is an element of arbitrariness, there is an element of malice in law, there is an element of pick and choose policy, definitely lordship can look into it. Why I am stressing on these 3 and 4? Because they have in their affidavit in opposition has, notwithstanding the fact that there are many others which is not denied, they are saying 320. They are talking about 2005, 2006, 2007. What is my career after being promoted as GM? They are silent, and there is no departmental proceeding. Now, regarding the Punjab and Haryana High Court judgment that was placed before your lordship, this is my last argument, my lord, today. My last argument on the, as a concluding reply. Regarding the Punjab and Haryana High Court judgment that was placed, I have gone through the facts. There the case was that whether within 5 years, referring to clause 10, within 5 years from the last promotion, a person can be compulsorily retired. There the law that has been most probably, in my humble submission as a senior counsel, law has been rightly laid down by the Punjab and Haryana High Court that if the promotion is on the basis of only seniority, then definitely it can be looked at. There is no, but my case was clause 7. My clause, your lordship will look at page 47 of the writ petition. This is the last trouble I am giving it to your lordship. Page 40. I'm sorry, page 80. Page 87. I'm so sorry.
Yes.
Page 87. Well, there is a wrong typing in my next page. 40. Actually, it should be 87. Clause 7. If your lordship will look at clause 7, may I read my lord? There is also no bar on the corporation to review any such case again where it was decided earlier to retain the officer. In my case, my lord, the review committee meeting that was there in 2021, they, on the basis of the same ACRs, same APRs, they came to a finding that I should be retained in service. Within 2 years, that means 1 year gone, 22 gone, 23, on the same entries, they found me fit enough to be compulsory retired. In this situation, clause 7 attracts. There is also no bar on the corporation to review any such case again where it was decided earlier to retain the officer, but the appointing authority is of the opinion that it is expedient to undertake the review again on account of same circumstances in public interest. In such cases, the appropriate authority is expected, your lordship will kindly see the word, expected to demonstrate visible meticulousness. Now, may I pause here for a moment? It is not in dispute that 22 they did not have 21 June. They did not have a review committee. It is not their case that review committee examined the case wrongly. No such things. The review committee, that 21 review, examined the same entries. They found me fit. Had it been a case of the FCI that review committee was wrong, or there may be a changed situation, suppose after being cleared, I have been caught red-handed while taking bribe from someone. This is a changed circumstance. The meticulous the order or the records must demonstrate visible meticulousness. That merely again repeating, going back to 2006 censure order, it will not suffice. My lord, only 2009, has your lordship got 2009 to move. My lord, I have a copy. Other day I gave it, my lord, I am giving it.
2009?
2009, 15 SCC, page 221. Yeah. Para 44.
Is this area 2009?
2009-15 SCC.
How we have that?
I have that, my lord. Most probably there was some problem in the pagination, so that's why I have given a copy.
Oh,
Para 44, my lord. I will not burden your lordship with all the entire judgment. 44 and 45. The power make.
yes.
Just small, short paragraph, my lord. I will. The power of judicial review of a superior court, although a restricted one, has many facets. Its jurisdiction is not only limited in the facts in the cases where the administrative orders are perverse or arbitrary, but also in the cases where a statutory authority has failed to perform its statutory duties in accordance with law. As an order which is passed on unauthorized purpose would attract the principles of malice in law. Paragraph 45. It is well settled principle of law that an order of compulsory retirement, compulsory retirement is found to be stigmatic inter alia in the event the employer has lost confidence or he has concealed his earlier record. However, he is subjected to compulsory retirement inter alia if he has outlived his utility. May I here pause here for a moment, ma'am? Here, from the bare perusal of the affidavit in opposition, their only thing they are hammering is on my that past censure, someone writing a letter that I have already given the paragraph also, my lord. Now, what on the point where they were supposed to show their visible meticulousness as per clause 7 of the circular, that is missing. Both in the impugned order page 64 as well as page 81. And paragraph 46 also. Was a small paragraph. They have quoted that Allahabad Bank officer's case. I just read my list, only half of it. I will not take your lordship's much time. The above discussion of case law makes it clear that the order of compulsory retirement casts a stigma on the government servant in the sense that it contains a statement casting aspersion on his conduct or character. Provisions of Article 31(2) of the Constitution. The reason is that as a charge or imputation is made, the condition for passing the order was, my lord, here also it was said that some unwritten stigma remains after being cleared by a review committee, again on the same thing, but it is not the FCI's case that the last review committee of 22 was wrong. They committed some mistakes. And last, my lord, next case was 1984 SCC, only one paragraph, my lord. 1984 SCC, page 321. There was some page, paragraph 8 and 9. At page 325, the judgment starts at 321. Relevant page is page 325.
Baldev, I think you have given us.
I have given, my lord. The problem was of that day I was taken aback when the entire pagination was wrong. What was given to your lordship?
Okay, but we have this printout.
I have, because I had that printout. But anyway, sir,
May not be required.
yes. May I read my only one paragraph?
Yes.
Paragraph 8.
Yes.
This takes us to meat of the to all of her, to the meat of the matter, is whether the appellant was retired because and only because it was necessary in public interest. May I have the indulgence of your lordship if you can read it.
This takes us to the meat of the matter, is whether the appellant was retired because and only because it was necessary in the public interest so to do. It is an affirmative, not a negative disposition, a positive conclusion, not a neutral attitude. It is a terminal step to justify which the onus is on the administration, not a matter where the victim must make out the contrary. Security of tenure is a condition of efficiency of service. The administration, to be competent, must have servants who are not plagued by uncertainty about tomorrow. At the age of 50, when you have family responsibility and the somber problems of one's own life's evening, your administration, if and only if you are not harried or worried by what will happen to me and my family, where will I go if cashiered, how will I survive when I'm too old to be newly employed and too young to be superannuated? These considerations become all the more important in the departments where functional independence, fearless scrutiny, and freedom to expose the evil or error in high places is the task. And the advancement task of the Office of Audit vested in the so-and-so and the entire army of monitors and minions under him are too strategic for the nation's financial health and discipline. That immunity from subtle threats and oblique overawing is very much in public interest. So it is that we must emphatically state that under guise of public interest, if unlimited discretion is regarded acceptable for making an order of premature retirement, it will be the surest menace to public interest and must fail for unreasonableness, arbitrariness, and disguised dismissal.
No problem.
To constitutionalize the rule, we must so read it as to free it from the potential for the mischiefs we have just projected. The exercise of power must be bona fide and promote public interest. There is no demonstrable ground to infer malafide here, and the only infirmity alleged which deserves serious notice is as to whether the order has been made in public interest. When an order is challenged and its validity depends on it being supported by public interest, the state must disclose the material so that the court may be satisfied that the order is not bad for want of any material whatever, which to a reasonable man, reasonably instructed in the law, is sufficient to sustain the grounds of public interest, justifying forced retirement of a public servant. Judges cannot substitute the judgment of the administrator, but they are not absolved from the minimal review well settled in administrative law and founded on constitutional obligations. The limitations on judicial power in this area are well known, and we are confined to an examination of the material merely to see whether a rational mind may conceivably be satisfied that the compulsory retirement of the officer concerned is necessary in public interest.
Well, so I conclude with the state. So I conclude, my lord, that the requirement of visible meticulousness post my after 2019 and after me being cleared in 2022 is missing. Number one. Number two, although they filed an application for leave after my filing the reply to file a surrender, I have examined it that when they took up the all grade 1 officers together, why some of them are left out? They have not denied that statement also on affidavit. But 21 or 20, and the Punjab case is relating to whether they can continue for 5 years without being touched after promotion because of clause 10. Court said nothing doing. But my case is a clause 7 because I have been considered. This is the only point of difference. Huh? Your lordship will look at clause 10. Clause 10 is a different language, closer to a different language altogether. Clause 10 is at page 87 of the writ petition.
Your case is
Clause 7.
clause 7.
Clause 7. That visible meticulousness is missing. After knowing that I was promoted, after knowing that I was cleared by the review committee. My lord, I am obliged for the patient hearing your lordship has given. With this, my lord, we conclude our order.
Just one thing, my lord.
He wants to argue it out again.
Just one point, my learned senior friend has just said about censure. My lord, petitioner was imposed major penalty also in the year 2016. Reduction of 2 stages for a period of 1 year. Then on appeal, it was
Yes,
reduced
I
to
have
1
given-
year.
I have given it in my
That
note.
is also comes under the major penalty, my lord.
I have already given in my first page of the, what are the 8 black points or black spots in my career. I am obliged, my lord.
The reply submissions by Mr. P.P. Pathak, Senior Counsel, assisted by Mr. B. Chaudhary, Counsel for the petitioner is concluded. Mr. D.K. Singh, Learned Study Counsel for the FCI is present. Yes, the verdict of the court is reserved.
Right.
The photocopy record produced is retained on retained with the record. This is a photocopy only.
Yes, ma'am.
Huh.
Print of E.
Synopsis of my main argument and today's reply argument is on the,
This one copy is extra. We are returning.
my lord.
Were not given. See. Order for impleadment of party, item 16.
Who do you want to implead?
May I please, Your Lordship, go ahead for implementing Commissioner and Secretary, Finance Department, Assam, as respondent number 3, Lordship.
Okay. Okay. By filing this interlocutory application, the petitioner in the connected writ petition seeks to implead the Commissioner and Secretary to the Government of Assam, Finance Department as respondent number 3. Mr. A. Chakravarti, the Government Advocate is for the
Respondent number 2, Lord.
respondent number 2 in the connected writ petition is present. Who's for JAD?
For A. Fukon, Lord.
A Fukon.
If done, study counsel for JAD, respondent number 1 in the connected writ petition, and Mr. Chakravarti, Government Advocate expert, representing respondent number 2 in the writ petition are present. This application stands allowed. In the connected writ petition, you say, your that's also your name
M. Das.
and please and Das, counsel for the petitioner. In in view of the order passed today in the connected IA civil, so and so. The Commissioner Secretary to the Government of Assam, Finance Department is allowed to be impeded as respondent number 3. Next, the petitioner shall provide a typed copy of the cost title of the petition to the AOJ civil rule pending section. So the concerned AOJ on receipt of the same shall incorporate the amended cost title in the petition and also cost correction in the central registry. Post stop. Let the matter be thereafter listed before the court.
Obliged.
Item 17 with 18.
Lordship, it's a matter relating to pay parity, my lord. After we filed a petition, the government side has informed that our department falls under the Department of Women and Child Welfare. So we have made the Principal Secretary, Department of Women and Child Development, as well as Director, Department of Women and Child Development as a party respondent.
Okay. Ms. B. Buyat and the senior counsel assisted by Ms.
R. Das.
R. Das, counsel for the applicants. By filing this interlocutory application, the applicant seeks to impede the Principal Secretary to the Government of Assam, Department of Women and Child Development, as well as the Director, Department of Women and Child Development, as respondent numbers 10 and 11 in the connected petition. Prayer is allowed. Interlocutory application stands disposed of. Petition same order. Huh?
Need to submit, I think that's as part of present.
That we have passed in the last order, same thing, it will be followed here. Yeah. After that, the matter would be listed before the court again. This 761 is also same.
Right.
Okay, same order. Next item also. Ah. Nineteen.
Impleadment for respondent as respondent number 8, my lord.
Whom do you want to impede?
My lord. My lord, it is the private respondent, my lord, that during pendency of writ petition, my lord, the railway department stated that, my lord, one lady submitted application representation for pension, my lord. And she is allegedly, my lord, most probably second wife, my lord. That's why, my lord, I have to implead that lady, my lord. Respondent as respondent number 8, my lord.
K.R. Kadgiri, learning counsel for the applicant. And who is the CGC appearing here?
My lord, DJ Das, my lord. DJ Das.
DJ Das.
My lord.
Mr. DJ Das, the CGC appearing for the respondent numbers 1 to 7. Filing this application, interrogatory application for the petitioner, the applicant seeks to implead the respondent number, the opposite party number 8 as respondent number 8 in the connected writ petition. On the ground that the opposite party number 8 has also applied for family pension. Claiming others. Claiming to be wife of the husband of the applicant. Mr. Clear is allowed. This introductory application stands disposed of. Same order, impleading, so this was respondent number 8. You file a amended cost item. All right.
Item 40 for orders.
No representation from the petitioner. Mr. N.J. Gogoi, counsel for the AS, A and B is present. First of all, as a justice, the matter is adjourned today. List after ensuing summer vacation.
Obliged.
41.
May please, your lordship, I filed a miss case to rectify the error, your lordship. IA number. In paragraph 2, your lordship, I made it clear. Paragraph 2, your lordship.
You want to delete few lines.
Yes, your lordship, that those were inadvertent errors, your lordship. I apologize for that, your lordship.
No, you'll have to at best withdraw it and file a fresh one, not to press it, because we can't allow you to amend the affidavit. We permit you to withdraw it and file a fresh. Do it within 2 weeks.
Deeply obliged, your lordship. I mean.
IE Civil 1927 of 2024. The respondent numbers 1 to 4 in the connected WPC 1111 of 2022 are the applicants in this interlocutory application. Full stop. Mr. T. Deori appearing on behalf of Mrs. R.S. Deori Standing also for the Soil Conservation Department had submitted that in the affidavit in opposition file in the connected writ petition, there are inadvertent errors. First of it is submitted that in paragraph 2 within bracket 1 of this interlocutory application, it has been stated that certain words mentioned therein were inadvertently inserted in paragraph 4 within bracket Roman 5 of the affidavit in opposition. Stop. Similarly, it is submitted that certain statement has been certain statement regarding the merger of Public Enterprises Department with the Industries and Commerce Department has been Industry Department and consequent renaming of the concerned department as the Industries, Commerce and Public Enterprise Department. It's required to be brought on record. First of all, brought on record in the affidavit in opposition. First of all. Heard Mr. A. Bhattacharya on the counsel for the writ petition in the connected writ petition. Next paragraph. As affidavit cannot be allowed to be amended. Court grants leave to the respondent numbers 1 to 4 in the connected writ petition to file a fresh affidavit in opposition in the matter. Full stop. In article, in view of the inadvertent errors in the affidavit in opposition filed by respondent numbers respondent numbers 1, 3, 6, and 7. There are two affidavits. Which you want to withdraw? Both are on 13.5.
Only one, Your Lordship.
Hmm?
Against the affidavit, the opposition filed against our additional affidavit. Both of them have to do, Your Lordship, because the miscase is only this one, Your Lordship.
So they do which one?
Extremely sorry, Your Lordship. Because against the affidavit that was filed on.
There are two affidavits filed on the same day.
Other one, 155. I'm extremely sorry, Your Lordship, I'm not getting the affidavit.
But
Filed on 13/5/2024, Your Lordship.
There are
We-
two affidavits of the same day. And both affidavits are affidavit against the additional affidavit filed by petitioner.
From 147 to 152 page, Your Lordship.
My lord, may I just point out?
147 to
One
152.
additional affidavit filed on 27/7/23.
I don't know.
This one, Your
I won't
Lordship,
apply my mind.
30.
Here's a document, you go through it.
I definitely.
Which one you want?
Page number 147 to 152, Your Lordship. Page number 147 to
147.
to 152. 153, Your Lordship. I'm extremely sorry, Your Lordship. 147.
No, you have to be sorry again.
Number.
Look at this. Identify your affidavit.
Sorry, Your Lordship. It's wrongly marked in my.
Now, just like कौन बनेगा करोड़पति, will have to ask you, lock कर दे.
Sorry. I apologize. Your Lordship.
You want to withdraw this?
Yes, Your Lordship.
Will you withdraw? Affidavit. In opposition filed by respondent numbers 1, 3, 6, and 7 on 13/5/2024. Within bracket page 157, U2, 163. Which was filed in response to the additional affidavit dated 27/7/2023 filed by the petitioner. May be connected with petition. Full stop. Next paragraph. On such. You say the writ petition law. In view of order passed today in the connected IA civil 1927/2024, by which order has been by which the respondent numbers 1, 3, 6, and 7 are permitted to withdraw the additional affidavit available at page 157 to 163 of this of the record of this writ petition, and to file a fresh affidavit in opposition.
Deeply.
It is provided that in the event such an affidavit is filed, the affidavit in opposition available at page 157 to 163 shall be treated as cancelled, and the fresh affidavit in opposition shall be kept on record.
May I submit something?
Yes.
During the pendency of the writ petition, there are certain developments. The board of directors of the corporation have taken a resolution that these petitioners will be given their retirement benefits. Accordingly, they have prepared the bill and sent it to the director of soil conservation.
Now, whether any development has taken place, let them get the also.
Your Lordship, I had the instructions, Your Lordship.
So is that a part of record?
Yes, I have put it in the additional affidavit.
Okay.
No, who made it?
You give a copy of this to him.
Definitely.
Take instructions.
Can a date be fixed, my lord, after
Hmm?
vacation?
You make a mention after that because every matter is being adjourned after vacation.
I'm deeply,
We really can't manage.
I'm deeply obliged, much obliged.
this after.
And I apologize again.
Yes, 42.
Well, it's instant I is filed to withdraw my affidavit in opposition. This is wrongly filed on behalf of respondent number 1 and 6. It's a typographical mistake. It is a mistake, my lord. I want to withdraw this affidavit in opposition and with liberty to file a case. Because in this case, my lord, respondents are CRPF and Assam Rifles. But I have shared the affidavit on behalf of 1 and 6. So this I also filed for withdraw the affidavit in opposition. File on behalf of respondent 1 and 6.
Yes, what is your objection?
My lord, Lordships should have the affidavit which was filed, which is sought to be withdrawn. Lordships kindly have that affidavit for a moment and just the affidavit which is sought to be withdrawn, my lord, that is with the writ petition at para 83. Few things might typographical mistake here or there would not matter. Lordship will find it page 83. It is an affidavit for respondent number 1 and 6, filed by one Lieutenant Colonel Sachin Vasdev, presently serving as Colonel Military Secretary. Lordship finds. And at page 84, I do not know, my lord, the first paragraph says, copy of the instant repetition has been served upon me where I have been arrayed as respondent number is blank. In my copy at least. And he was not a party to the repetition to have filed the affidavit in opposition. Thereafter, Lordship would see that having authority, I am showing this affidavit on behalf of the respondent number 1 to 6. Now, Lordship would have the IA. The IA which is listed today.
Yes.
Lordship will find it paragraph number 3 at page 5 of the application. The applicant begs to state that the above mistake has come to the knowledge of the applicant subsequently and therefore the applicant respondent number 3. Now, my lord, this is signed. Lordship will find it the affidavit post by an assistant military secretary who was not the person who signed the original affidavit.
That's okay. They get transferred.
But he is even of a lower
Because if he's filing it, it must be within his competence to do it.
It is not stated anywhere that he is competent to withdraw the affidavit filed by a senior officer. The other was by the military secretary. This person is not the military secretary. There is no difficulty. They may file a fresh affidavit, they may come up with everything. The number of mistakes committed, 1, they were not supposed to have filed it against this on behalf of the CRPF in the affidavit in opposition. They have leveled all sorts of allegations against the CRPF. In the original affidavit, purporting it to be filed on behalf of CRPF also, every allegation has been leveled against the CRPF authorities. To the extent that they are acting hand in glove with the petitioner, that also sentence Lordship may find.
So only that extent that this care is not one of the advocate. What was started with that it was his mistake, it is not his mistake. That sympathy Lordship would perhaps not have. If the mistake is by the deponents, by the officers concerned, then that statement should not come that it is my mistake, I mistakenly typed 6. It is not only that paragraph, that respondent number 6 is to be changed. If that is the only change they want, Lordships will allow them to make a pen correction. Strike of 6 if that is the only objection. They now intend to change the entire tenor of the affidavit in opposition. Can that be allowed? Is the issue. Lordship would kindly have the page 94, my lord, how they have stated, what they have stated in this affidavit, then this should not be allowed to be changed. Page 94, just above para 11, Lordship will find. Lordship finds the fourth line from above para 4. Thus, filing of this petition is just a tool. Lordship finds the sentence.
Just now.
If the whole tenor is changed, the entire case would change. Page 94, Lordship would have para, just above para 11. Thus, thus filing of writ petition is just a tool being used by the petitioner duly supported by Inspector General, Composite Hospital, Guwahati to keep getting his tenure extended. Then Lordship would find it page 97, another allegation. The last few lines, page 97. The fault here also lies in the functioning of Composite Hospital CRPF, as they also did not corrected the course of action, rather partied with him with myopic view of accrued benefit of their.
You're reading where?
Page 97, the last line. Second last line. Order to have extended tenure. The fault here also lies in the functioning of Composite Hospital CRPF Guwahati, as also did not corrected the course of action of petition and rather partied with him with the myopic view of accrued benefits to their Composite Hospital. Then finally, Lordship will have page 99. The second paragraph, fourth line from the below. Sentence starts with Directorate letter dated 1 April 2022. Again, no action was taken by Composite Hospital CRPF Guwahati, nor any effort taken to clarify the issue with DIGS per CRPF, as copy of additional BG was also forwarded to him. In the entire affidavit in opposition, they have simply leveled allegations against the petitioner and the CRPF, claiming
What
the
is
affidavit.
what is the case about?
My lord, they had a certain transfer policy by which persons who entered the forces with a PG qualification and persons who acquired the PG qualification, doctors who acquired the PG qualification later, were supposed to be centrally transferred around. Their posting was to be done by the MHS centrally amongst all the forces. Each of the force, particularly the Assam Rifle, they were retaining all the doctors, all the qualified doctors at small medical units where their specialization was not being taken care of, was the loss of the government. But otherwise, these doctors could not go ahead even with their own experience of practice. They were trapped in small locations. Therefore, when the new policy came that they should all be transferred by the central, that was not being followed by the Assam Rifles. Particular petitioner was posted from the Assam Rifles to the CRPF. Only prayer before this honorable court was, let this central posting be done. I will go where I have to go. It cannot be done by the Assam Rifles by keeping me in that small village because the policy has now come into force. Stay was granted by this honorable court saying that you do it according to the policy, there is no stay. You don't do it according to the policy, there is a stay. That was the condition. Then they filed this affidavit in opposition, saying that the CRPF is acting hand in glove with the petition. This is brought to the notice of the CRPF. CRPF says, how can allegations be leveled against us? And how can the Assam Rifle reply to us? for us. We would have given our own stamp. It is then that this IAS filed to withdraw this affidavit. Now, if the only issue is that he should not have filed it for the CRPF, that will end the issue. We can just track off the name of respondent number 6 at the relevant paragraphs. But now with this withdrawal and they coming up with a fresh affidavit, they will try to change the entire tenor.
But how will you be prejudiced? Supposing they whatever you have shown,
Yes.
they withdraw it. How will you cause prejudice?
Now, my lord, when they said in that affidavit in opposition that the Central Reserve Police Force is acting in hand in glove with me, and when that particular department would come up with a standard, no, this is the law being followed, that would have supported my case.
No,
They
you
try
can-
to put
they
all the
can-
blame
they can-
on a particular force, saying that I am acting hand in glove with them or they are acting with me. That is the exact word used. They are partying with me.
Oh, that's okay. But still,
Otherwise, if lordship allows, my lord, there is no difficulty. Let them come up with the correction. I have no difficulty on arguing of the matter. Once pleadings are complete, there is no difficulty. But this being filed in, what I was just trying to point out is, my lord, the manner in which the affidavits are filed, and if it is let go so easily, at least in the Assam Rifles, every other affidavit, my lord, this is happening where even the respondent number is kept blank. Affidavits are being filed.
My lord,
And that is the only objection. Otherwise, my lord, there is no
will be
difficulty.
allowed to file affidavit separately from Assam Rifles and the CRPF. Because some mistake is there, my lord. And the policy is on the consideration before the ministry.
That is the merit of
And,
the
and I have authority to swear this affidavit because I have a delegated power. This is the letter from the ministry, my lord. Office of the Ministry of Home Affairs, Office of the Additional DG Mads, CRPF, Energy and Assam Rifles. My sir, last line, my lord. 10, para 10. Therefore.
no, this does not give them authority. This is not an authority letter.
Yes, my lord, they have delegated power, my lord, to swear an affidavit. Because there is some mistake, my lord. But instead of swearing the affidavit,
No, you see, Mr. Mazumdar is taking a technical argument that how can you the present applicant, the deponent in the present application is ranked junior to the one who gave that affidavit. How could you withdraw that? That's the question he's asking.
my Assam Rifles is
It's not
Right.
a withdrawal of affidavit by the same person. Somebody else is coming and saying that this the earlier affidavit is to be withdrawn.
yes.
So he's challenging the propriety of that. Affidavit was filed by X. Y has come to withdraw it. It is not your case that X is not empowered to file that affidavit. So an affidavit by X, how can Y withdraw it?
It was swear by the Director General of Authority of the Director General of Assam Rifles and the affidavit IA is sure by the AMS Director General of Assam Rifles. Same authority, my lord.
In the IA itself, your lordship will have page 2, respondent number 3. It is the Director General. And if lordship would have the affidavit supporting it,
You go Director General Assam Rifles.
yes, and at page 7, it is Lieutenant Colonel Amit Shah, who is an assistant military secretary and posted at headquarters DGI, who says in the first paragraph that I am respondent number 3. Lieutenant Colonel Amit Shah is not respondent number 3. He's applicant number 3. He's respondent number 3 in the petition. He's not the Director General. This carelessness is what I want to point out, madam. This totally is filing an affidavit for an affidavit's sake. This is what I was trying to point out. Anything given in the court, they deem it will be taken, it will be.
No, Mr. Datta, this can't be allowed.
If they do it properly, I would not have an objection. They will resist my
He's not
petition.
respondent number 3. He's not respondent number 3. Respondent number 3 is the Director General.
Of money.
Director General is of what rank?
Well, the Director General, I think it's they usually at Colonel. They usually at Colonel Swinch or the Brigadier. Because that is the military formation they come from. In the other CAPF, they come from the IPS. In the police force, the top rank is the Director General. Since here they
He's
come.
Assistant Military Secretary.
Yes, he's a different person. He's not the Director General.
He's not the Director General. We can't allow this application.
In fact, the applicant, there is only one Director General is the applicant. At page 3, lordship will find Director General is the applicant. Page 4, lordship will find Director General CRPF is the respondent for the IA. Not even the Director General of the Assam Rifle. He is claiming to be the Director General of the CRPF now. This total has to stop. Assam Rifles, they take it for granted. Otherwise, there is no difficulty in their coming up with a proper affidavit. I always try to defend the case.
Mr. A.K. Datta, CEC appearing for the applicant. By filing this interlocutory application, the applicant, i.e. the Director General, Directorate General Assam Rifles, Shillong, is praying for withdrawal of the affidavit in opposition filed in the connected writ petition on behalf of respondent numbers 1 to 6. To stop, the applicant is also seeking liberty to file affidavit in opposition on behalf of respondent number 3. Full stop. Next paragraph. Mr. R. Majumdar, learned counsel for the opposite party, who is the writ petitioner, has filed an objection to this interlocutory application. Next paragraph. The learned CEC has submitted that there's some inadvertent error in the affidavit in opposition filed on behalf of respondent numbers 1 to 6. For which the said affidavit is sought to be withdrawn and to be with liberty to file an affidavit in opposition on behalf of respondent number 3. Full stop. As pointed out by the learned counsel for the opposite party, there appears to be incorrect statement in the affidavit filed by Lieutenant Colonel Amit Shah, SAH, who has claimed that he is presently serving as Assistant Military Secretary and posted at HQ DGAR Shillong. And in paragraph 1 of the affidavit, it is projected that he is the respondent number 3. Full stop. Next paragraph. Lieutenant Colonel Amit Shah has stated in the affidavit filed in support of this withdrawal application, this interrogatory application, that he is serving as Assistant Military Secretary. First of, therefore, he cannot be respondent number 3, who is the full stop, as the respondent number 3 is the Director General, Directorate General, Assam Rifles, Shillong. Full stop. Next paragraph. It is further observed that the affidavit in opposition filed in the connected WPC 3400 of 2022 was by one Lieutenant Colonel Sachin, SACHIN, was the VSDV. Which stated that he was arrayed as a respondent in the connected in the writ petition. And he was serving as Colonel Military Secretary at HQ DGAR, Shillong. Stop. Neither Lieutenant Colonel Sachin Vasdev nor Colonel Military Secretary is a respondent in the connected WPC 3400 of 2022. Stop. Next paragraph. Apparently, the person who had filed affidavit in opposition on behalf of respondent numbers 1 to 6 in the connected writ petition on 29/5/2023 was of a rank of Lieutenant Colonel. Full stop. Therefore, the present application is filed by a person who is not of the same rank. He appears to be holding a post which is below the rank of Colonel. Lieutenant Colonel. So there's nothing on the court to show that the authority which has filed the affidavit in opposition has empowered the deponent in this application to withdraw the application, withdraw the said affidavit in opposition. To stop. Next one, you. Above, comma, the objection made by the petitioner in the in this interlocutory application is accepted and the interlocutory application stands dismissed. Stop. Next, the dismissal of this interlocutory application shall not be a bar for the competent authority to make an appropriate application. We are returning you this.
Millet, I may be given liberty to file.
We have given it. We have given it.
In the writ
Page
petition,
52.
in the writ petition, my lord, the orders were that the interim orders would continue till the next date of listing. If this is considered as a date of listing, my lord, perhaps it has to continue. Or
We collected this petition. This was involved for the petitioner and if it is for the petitioner. This immediately after the ensuing from the petition, interim order passed this and extended to the next state.
I'm obliged.
52.
May I plead your lordship? This I is for correction of a typographical error, your lordship. Well, lordship, we're extremely sorry, your lordship. There was an inadvertent error in the cost title of the writ petition, your lordship. The respondent number 3 ought to have been executive engineer PWD Koliabor Road Division Jokhlabandha instead of superintendent engineer Kokrajhar ED Circle, Kokrajhar, Assam.
Okay. But Mr. F. Hussain, the counsel for the petitioner, applicant. As well as Mr. For PWD, you are there, Mr. Hardhar, standing counsel for the PWD, appearing for the respondents, opposite parties. Next paragraph. By filing this interlocutory application, the applicant who is the petitioner in the connected writ petition seeks to amend the cost title in respect of respondent number 3 by substituting superintending engineer, Kokrajhar E and D Circle, Kokrajhar, Assam, with inverted commas, executive engineer, PWD, Koliabor Road Division, Jokhlabandha, inverted comma closed. Full stop. The prayer is allowed. I guess include the application stands disposed of. The petition is right. But Mr. F. Hussain, counsel for the petitioner, and Mr. Hardhar and standing counsel for the PWD. Next, in view of order passed today in IS Civil 1954 of 2024. The respondent number 3 herein is allowed to be deleted and substituted by inverted in executive engineer, PWD, Koliabor Road Division, Jokhlabandha, inverted closed. The petitioner, the learned counsel for the petitioner shall provide a freshly typed cost title of this petition to the AOJ, civil pending section. On receipt of the same shall make necessary corrections in the cost title and we shall incorporate this freshly typed cost title in this petition and also correct the central entry Full stop. Next matter, pending. The pending such amendment, if you notice on the substituted petitioner number, sorry, the corrected respondent number 3, which is returnable in 4 weeks, requisite extra copies of the requisition be served on the Learned Standing Council for the PWD. Would accept notice on behalf of the newly impeded respondent number 3. Next para. Let's start for 4 weeks.
Deeply obliged.
Item 20 and 21 for admission.
May I please, Your Lordship? I'm appearing on behalf of Mr. D. Bora. In the morning, I had mentioned these items for adjournment.
Oh, yes. Okay, your name?
R. Duara,
You're for the petitioner.
petitioner.
Okay, but Mr. Ardwara and counsel appearing on behalf of the counsel and record for the petitioner. Mr. R. Dhor and additional senior government advocate is present. First of on the prayer made by learned counsel for the petitioner, the matter stands adjourned today. This after answering summer vacation.
22, 23 and 24.
In this matter, my lord, we have filed an affidavit.
Just now. The registration delete the name of the name of the first counsel for the petitioner. Or means elevation to the bench. And accordingly, his name may not be the name of the and accordingly, said name may not be reflected in the cause list. Well, listing the matter next. Yes.
My lord, we have filed an affidavit regarding what these 3 cases are covered by a judgment.
Which matter?
This by 22, 23 and 24.
22, 23, 24. Yes.
Same matter, but it is covered by the my lord, earlier judgment. It is a my lord, the job case for job. This is a FPSC matter. That's a my lord, honorable single judge my lord, on. It is reported in 2028 3 GLT 800. That is to cover our affidavit relating to only my lord, that this matter is covered by this judgment. Our affidavit, lordship, kindly see page 17.
Okay, we get it.
Yes. Covered, it's purely covered.
Lordship, for withdrawal of Fokalatdama was in connection with item number 23 only. For 22 and 25, where I am appearing. My senior was appearing, Your Lordship. Lordship, these 3 writ petitions were kept separate. Lordship may see the order dated 22/1/20, Your Lordship. At that time, it is reflected thereon, Your Lordship.
22.
22/1/20. There is the order of this honorable court.
No, it is separate because it came later.
Lordship.
But it is covered by the same ratio, so we have to close this matter being covered by the judgment of this court. We cannot take a different view.
Yes, my lord.
Lordship, in connection with 23, my senior is appearing today.
Appeared at item number 23.
No, one by one. First is item
22.
item 22.
22 and 24 read by mice.
No, that's okay. We're coming one by one.
22, 23. read
No,
by the
no.
local
First,
account.
let me complete 22, then we'll come to 23. So 22,
We have filed affidavit.
so in 22, we have to say that this matter is already covered.
Yes.
Your name?
Lordship, S.A. Hussain, Your Lordship. Lordship,
S.A.
my
Hussain.
humble prayer before your Lordship is that since these three matters are being taken together, Your Lordship, for item number 23, probably my senior is seeking an adjournment, Your Lordship.
Please, we'll come to 23 when we call up 23. Now we are in 22.
Lordship,
In 22, it is a covered matter, so we are closing this, saying that the ratio of the case, reported case, which the additional senior government advocate is submitting. Yes,
Lordship, on instruction, I have sought instruction from the petitioner. I'm yet to obtain the instruction. On
instructions on law you are getting from your client.
Lordship,
You
this
can't accept that.
Lordship,
You see page 17 of the, page 121 of the affidavit. If it is,
Lordship, it is there. These matters were, Your Lordship, kept separately also because the service rules were also different in these three matters only. Others were from the arrested from the same allegation, same PS case number.
what is the service rule involved here?
Actually, Lordship, this matter was being taken up by my senior. I'm not prepared for this, Your Lordship, today.
No, I am told by the additional advocate general, my lord, they have filed this affidavit. They have said that these matters are squarely covered by the judgment.
No, but let us see what is, this is, petitioner is Satyajit Sarkar.
Yes.
He's the assistant employment officer.
Yes. Falls within the category of this judgment, my lord. It is already discussed in the case law. Department is, my lord, labor department is there.
Employment officer is.
Assistant employment.
So page 126 you are covered. Assam Labor Service.
Yes.
Okay, Mr. S.A. Ahmed, counsel for the petitioner is present. We praise for an adjournment. Mr. T.C. Chutiala, additional senior government advocate. Had has submitted that the issue raised by the petitioner has been decided by this court. In the case of Gitali Dole and GWTALI Dole DOLEY and others versus State of Assam and others, comma 2020 within bracket 3 bracket closed GLT 800. And another connected cases. Full stop. By referring to the order dated 22/1/2020, it is submitted that 3 writ petitions were fresh matters and could not be heard, and the other matters were heard and reserved for judgment, which was subsequently delivered. First, it is submitted that the ratio of the said case would squarely apply on the facts and circumstances of the present case. Next, it is also submitted that the case of the petitioners, well, that the petitioners belong to the Assam Labour Service rules, 2007, and that in the APSC scan, there were other members of the Assam Labour Service whose cases were heard and decided. Along with the case of heard and decided in common with, along with the case of Gitali Dole and others within bracket Supra. Next, in view of the appeal made by the Honorable Counsel for the petition, the matter stands adjourned today. List of time saying summer vacation. Now, item 23.
Madam, now we have appeared, madam, recently. So, my lord, we have not received all the document, all the relevant document from my client. So they have, as per my order, they have claimed that they filed an additional affidavits, and also that is not with us. Whatever maybe we want to verify with my client. So we need some time to file and at least affidavit and reply against the affidavit of opposition filed by the reference number 3. It is very much required. You also need some modification of the writ petition on for which my lord, you also file an additional affidavit. So on the ground, my lord, we need some time.
No, but your case is covered. How do you save this matters?
How you develop it?
Covered.
Are you a party in the trial before the special judge? Are you a party? Are you an accused in the trial before the special judge?
That is why I have not received all this document. My lord, recently has come. We filed just they have put on their Ukalatama.
No, then your client is otherwise also unworthy.
That is why we need to sit together.
So you are admitting that.
And that is why we need some time. And
no, it's not a question, because if your client is an accused or not, even if he does not know that.
Maybe that is the
No. We won't permit you to play with the court. If you don't know, we dismiss it.
My lord, she's a accused, my lord.
She is an accused. Now you see.
Now, that is why, my lord, we have to go through entire documents. Then we can. That is why, my lord, this is my first submission. We need some time to.
Unnecessarily, people say that this police uses third degree.
That is why, my lord, it is a
and
case of
they are doing custodial torture.
We have filed, my lord, 4th of June.
No, that's okay. I was just thinking that people come to court and say that they have been tortured in custody. But we are people who need some custodial torture to get out the correct things.
We have to go through. I cannot say, my lord, this way, that way, before this honorable court. That is why I need some time.
The matters are similar, and whatever instruction he will receive, that will be also merged with this judgment. What, how he developed this case, my lord, already decided after hearing length, at length, my lord, 40 beds of writ petition. 49 beds of writ petition.
And because here also Mr. AK Peters also appeared, he also already broken his wrist, that is why. In presence of him, because he also engaged, that is 30 days time may be allowed. To file in the meantime,
He will never do a case.
Huh?
He will never do a case.
not it.
I've never seen him accepting taking an adjournment. Once the court puts an adverse question, then he pays for an adjournment. Doesn't do the matter. Sorry to say it. Yes, sorry to say it, but whenever we ask confirmative questions, then it doesn't.
He also one
It
of
takes
the
an adjournment.
He is not to do the case. It is otherwise my client will say something. So this is the first time is my lord listed after my filing my Kalasama. So that is my humble submission. It fixed on first week of August for admission. In the meantime, we file and reply.
No, we are admitting it and putting it for hearing.
My lord,
It will not come in this.
my lord,
I say it's okay.
lordship by the first part
Okay,
of
just hear us. You have filed your wakalatnama?
My lord, we have filed.
Hmm?
Yes.
When?
My lord, I don't know.
If Paul Leonard Counsel submits that he has filed his wakalatnama in the matter and he prays for adjournment. It's same paragraph here. It's clearly covered by so and so. The petitioner was posted as assistant employment officer and therefore same labor inspector, same thing. Adjourn today. Just say one more line. Full stop. The pendency of the writ petition shall not be a bar for the concerned trial court to in session of in session SEISN in session of the criminal prosecution of the petitioner. At least after ensuing vacation, the summer vacation. In the earlier order also, right, the pendency of this writ petition shall not be a bar for the trial court in session of the criminal prosecution of the petitioner to proceed with the trial.
My lord, my submission in the first part of my August.
I am not saying anything. After vacation, the registry will fix the dates.
That is why my date will be fixed with.
No, we are not fixing any date.
Well, my lord, first part of let it come first.
We are not fixing any date. Let the registry do it.
Sets date. I'm just the first part of August. That is why.
Even first part of January 2028, we are not fixing. Let the registry fix it. After vacation, we are not giving a date.
After vacation, I not be here, my lord.
I am not giving a date.
That is why, my lord, that is my humble submission, my lord.
We are not giving. We are refusing. You are not entertaining out there.
My lord, much of
24.
Lordship, 24 is also same employment officer. And a trial is going on in this case, Your Lordship.
Same number one, Mr. S. A. Ahmed. Same order.
three matters will come together, madam.
Will come together.
Because we have filed one affidavit in the item number 22. It covers 23 and 24.
Only the provision, I will get it clear with my senior, and your lordship may dispose of on the other day, your lordship, whenever.
No,
it is
we have seen that provision. Don't worry.
That's it. As per instruction. Much obliged.
Next time, don't take instructions on law from your client.
Lordship.
Item 26 to 31.
These persons who are working as grade 3 and grade 4 in BTC minor. Written termination of service, we have appealed to the Honorable Court. Honorable Court was pleased to issue notice and protected our service by ordering that status quo as on the date be maintained, your lordship. They have not filed their affidavit yet, my lord.
Lordships, multiple cases filed in different departments. Lordship, we have filed in some cases affidavit which are not listed today, Lordship. So, Lordship, I am praying for accommodation today, Lordship. After vacation, Lordship, we shall file affidavit in these cases also, Lordship, and let the matter, all the matters come along with Lordship after vacation, last week of July, Lordship, so that we can file affidavit in these matters also. Some cases we have received instruction, and other cases we have filed affidavit. I am giving the detail, Lordship.
You're working or not working?
That instruction I do not have, my lord. Although honorable to protected our services.
So we are asking you because there's an order of termination, right?
Lordship, two of the
After
cases.
termination, there's a status quo order. So that's why we asked.
Lordship,
Nothing.
so similar cases came up, my lord. We were
No,
under
it's
the
okay. It's
impression,
okay.
my
We are,
lord.
we are not,
But
we are
some
not-
of them are working as on date, but these,
Okay.
as regards these petitioners, I have no instruction, my lord.
Okay.
I'll take instruction, my lord.
Ms. B. Bhuyan, Senior Counsel, assisted by
Ms. M. Chakraborty.
Ms. N. Chakravarti, Counsel for the petitioners. First of all, this is R. Borobara, Standing Counsel for the BTC. Praise for him is granted. We are granted 3 weeks time to file affidavit in opposition in the matter. Mr. R. Dhor, an additional senior government advocate for respondent 1 is present. Let's start answering some occasion.
Lordship, may I pray for?
Other matters, so list along with this matter, Lordship. I am-
No, right now we are not doing it. You see, after vacation, we don't know the position.
Lordship.
So this matter, we are adjourning it after vacation. Other
Yes.
matters, we are not tagging it right now. You make a mention before the registry,
Yes.
all the analogous cases into the registry.
Lordship.
Lordship, may I pray my lord status quo, which is granted in our
Okay, anything
favor.
about the past earlier stands extended till the next date of listing.
Right.
Deeply obliged.
Oh, 26 to 31 are tagged.
Yes.
Okay. Same, what do you call common order? Okay.
Mm. 32.
This matter pertains to appointment of a Gambura. Yes, we have challenged the selection process. Pursuant to the last order, an affidavit has been filed, will file a short reply letter. You may fix it any date after vacation. As per the records corporation.
But now the appellate authority is there, so we'll closing this, all this repetition, you file an appeal under 162C. The appellate authority is now constituted, is taking up matters.
But will make a submission on that also, because this matter has proceeded, all pleadings are more.
But still because earlier they were not functioning. So we were entertaining the writ petition, but now since the appellate authority is there, why should we determine what do you call, how will you, why will we adjudicate questions of dispute? You see you are saying that you are more suitable than
No,
Mr.
Lordship,
Mr. Datta.
no, Lordship, our case is little different, Lordship. May I please? Lordship, what has happened, page 24, Lordship. would see
No,
my-
no, your case is that you are more,
No, the selection process is hit by externals consideration. After the selection process, a letter was given by the
No,
chief
that
minister.
that is one part. That is one
Recommending.
part, but you are claiming that you are more suitable.
Yes, so that is.
So suitability is, and the qualifications and those are disputed questions of fact between you and Mr. Datta.
Lordship, but suppose if the selection process is illegal, Lordship, the entire selection process would go.
Do you think that the appellate authority is incompetent to declare that?
But Lordship will take this matter after vacation, Lordship. Lordship will pass any order, Lordship will prepare on the point also. Selection process. The selection is gonna rightly selected or not, that will be a see with the appeal. They will pass over. What's the president reconsider with it?
Okay, all sides are represented. This matters after issuing summer vacation on a date to be fixed by the office. On the next date, all sides will address the court on the alternative remedy being available under section 162, capital C of the executive instructions under the Assam Land and Revenue Regulation, 1886.
35 with 36.
May it be the lordship. In this matter, on the last occasion, your lordship was pleased to give a direction to the respondents to produce some records, my lord's instructions relating to.
Lordship, here we have written to the commission. Commission has communicated me praying for some more time because they have to, since the examination was conducted by SEBA, Lordship, they have to collect those marks and everything. Some more time is required. Lordship may take it up immediately.
Mr. Suthia, please find out what is the bottleneck, because it was conducted on your behalf. Now there 2 dates have gone by. So we just wanted to look at the result.
I think
What you
we
call,
have-
and that is category wise.
Hello, we have sent a result to the authority. We only conduct the examination. Thereafter, we send all this thing to the authority. He will put it, we can put it.
No, Lordship, those are not available. They have communicated to the SEBA. They will receive it from them. The commission will receive it. Lordship, on reopening, Lordship. Yes.
All sides are represented. Mr. B. Chaudhary, done as standing counsel for the SLRC. Come upon instructions. Raise first. For the 2 weeks time. We'll make it 3 weeks. 3 weeks time to file, to produce the to produce the marks in terms of order dated 7/6/2024. Stop. Just after 3 weeks.
In all the three cases, madam, same order,
Same order.
same. 35, 36, 37.
Same order.
I'm obliged. May I pray for a convenient date, my lord, if it is.
Which we are not fixing right now. Make a mention. We are.
Yes,
If I read sent right now.
No, my lord, no problem, my lord. I'll
Make a mention. We'll.
35, 36, and 37. Yeah. Obliged, my lord.
How's senior Mr. Bragwan? We are not seeing him for quite some time.
My lord.
How's senior Mr. Bragwan?
Yes, my lord, he is fine. He's having some seasonal cough and flu also, my lord, for last couple of days. This is happening everywhere. We also been infected
We
for
have
some.
seen him for some time. That's
Yes,
why
ma'am.
I asked him. Okay.
He comes only when there are some matters, sir. Otherwise he's taking rest. I'll convey, my lord. I'm deeply obliged, sir.
38.
38 also, Lordship, similar, it's with regard to grade 4. Lordship, here also I pray for some time. Lordship.
Okay, same connected matter.
Yeah.
Okay, your name?
And Nastin, my lord.
Yeah, and the same counsel for the petitioner. Same one. Okay.
Obliged.
Obliged.
Item 43 for hearing.
In this case, my lord, I'm paying you a little accommodation today, my lord.
Otherwise also,
Yes, ma'am.
not intend to take up today.
After vacation, ma'am.
We do. With a positive time matter cannot be taken up today. Also, as a represented, list after ensuing summer vacation.
I'm for respondent 8 minutes.
I was in all sides represented.
That's all.
Okay, then.
Other hearing matters will be adjourned. We will not pick up the hearing matters. Well, you are all planning for vacation. I am planning for a what you call list of reading materials because I have to attend the a regional conference on next Saturday and Sunday. So
Thereafter also we will get time. Thereafter also we will get time.
All CAB method.
no, so that's why. While you are planning for a vacation, I am planning for a reading.
We are planning, brother. Where are you going?
Actually, from tomorrow is bar elections. From tomorrow we will take it. Tomorrow is bar elections.
Good day for dismissal of matters. People who are not representing. We'll take care to take up those matters. Get only those matters listed where bar members are. Okay. Best wishes to all.
Thank you.
All the candidates.
But I am not coming.
You're also best. Okay. So best wishes to you also. My study material is about 800 pages for those 2 days.